Alright, hello everyone. I'm moving my mic closer to me right now. Can you all hear me? Am I audible and whatnot? I'm gonna open up my can of Dr. Pepper Zero to see if any of y'all are on, but just are dazed out. It's ASMR now. Alright. Looks like there we go. Looks like I am indeed audible. Welcome everyone to a very special Flowergothic stream. Yeah, today we're doing something a little bit special. Oh. Fuck! I just realized there was like an ad playing like the entire fucking time. Like I was just chatting. Fuck! Because like my primary like streaming outlet is Twitch. And I'm on like that level where it just plays ads at random intervals, so fuck. Okay. Am I audible now, y'all? Can y'all hear me? Alright. Looks like I'm being heard. Everything's going all good. Welcome everyone to this wretched day. So you might be wondering why I have Ragdoll here today on this lovely Saturday, November 1st. Well, in the past week, I have gotten some documents, legitimate Brazilian legal documents, that, well, kind of expose the Piquet family as financial parasites and legal terrorists. And today, we're going to read them together in both the original Portuguese and the English side by side, and just, you know, kind of get a taste as to how fucking insane this family is. Yet again. I like printed out, hang on, let me, there we go. I like printed out like 3 pages of like the first lawsuit we're gonna go over, but I honestly don't know why I did this. I was gonna do it as a preview, because originally it was just this. And today Flower shows that she has no sense of perception. It was usually just this, but then I found a shit ton more, specifically those regarding the older 2 kids, Kelly and Nelson Jr., and I figured it was very much worth just kind of doing an all-day stream, looking around, seeing what's going on. I'm going to flip these two. There we go. So you can actually read the English with me. Okay. I'm also going to put on a little bit of lo-fi music just in the background if you don't mind, just so we can have more than just me yapping in the background. Royalty-free Twitch music. And y'all are more than welcome to comment, like, reply, send to your friends, your lovers, your enemies, your rabbi, everything, everyone, just whatever the fuck you want to, yeah, sorry, it's been a while since I've done, like, a stream of this exact nature. Hell, this might even be the first time. I don't even remember doing a stream of this nature. And, I guess I'm a little nervous. Anyway, let's begin. Where's the royalty-free lo-fi? Any that's like more than a half hour? Chill royalty free for Twitch. 4 hours worth. I honestly don't know how long I'm, so I'm like just trying to find one where I just don't have to like change the playlist. No 5 royalty free, 39 hours. I'm definitely not gonna be streaming for 39 hours. This is our best bet. Exclusive from taste profile, play. There we go. Oh, hey, Timothy. I got a new... Okay, just a brief aside before we get... I got a new printer recently, and Timothy has taken to just sitting on it. Just kind of vibing. Here, let me show y'all real quick. Ah. No! And he just left. I promise you he was there, though. And my tape just fell. Whatever. Hey, Timothy. Are you trying to wink at me? Okay. So, while we wait for more people to kind of come in and just kind of as a warm-up, I wanted to go over the original Nelson Sr. racism lawsuit, partly also because this is the one thing I have to say that is human translated. Thank you to Mia. Timothy said no, obviously, so I don't know if Mia is in the chat anywhere or wherever she is. Thank you so much, Mia, wherever you are, for doing this. And this is what we're going to start off with. It's the longest of the papers, I think, at like 85 pages. But it should give us a sense... Oh, you're Mia. Hey, Mia. I didn't recognize your username. Wait, I just realized I don't have, like, chat up. Maybe I should have chat up. How do I get chat up in here? Chat box. Add source. Clean. It's probably only going to show Twitch chat, but other than that, I guess we're good to go? Oh, she did? One moment. I gotta see this for myself. I have like a spare browser in here. Stories. They're loading. Oh, damn, that's... We're not going to be talking about that story. And that's the tease. But thank you for subscribing. We're not... Anyway, let's actually read this goddamn case. I don't know what we're not going to talk about it. We're just gonna... She posted something, and honestly, frankly, I don't care. There's nothing I can really say about it without getting into some really dark territory and into more speculation. So we're just gonna shut the fuck up about it and just keep on getting our shit in here. So this case is especially interesting to me because yeah, that's all we're gonna say about it. She posted about the reveal. That's all we are going to say about that, and we'll leave it at that. From a year ago, not a new one. Yes, from a year ago. That's literally all that happened. We're not going to be talking about it from here on out. We're just let's just drop the fucking conversation, y'all. Let's just talk about this bullshit. So, this interested me particularly because do not name the child by name, please. Do not. Please don't do that. You think she posted that in a way just to get us distracted from talking about the main issue at hand? You think? Make of that what you will. Anyway, this fascinates me particularly because they actually cited some academic sources to indicate why exactly what Nelson Sr. said was racist. So, we're gonna start with this. It was 3 Brazilian nonprofits that focus on human rights, minority rights, LGBT rights. So, that's just what all of this is. These are all the groups. Oh, it's 4, my bad. It was 4 people that sued Nelson Piquet Sotomayor for this bullshit. Now we can get into the synthesis of the demand. Okay. The plaintiff associations, through this public civil action, request judicial protection for the compensation of the collective moral damages and social harm inflicted on the black population, the LGBTQIA+ community, and the Brazilian people in general, due to the serious racist and homophobic offenses uttered by the defendant, who bears the responsibility of carrying the public image of a 3-time Formula One world champion Brazilian athlete, and therefore a world-renowned public figure, in the face of the Black English 7-time Formula One champion Lewis Hamilton, in a hasty and nauseating interview given in November 2021, and which gained immense notoriety in Brazil and around the world in June 2022, triggering a gigantic wave of outrage and indignation. During the ill-fated interview, in which the defendant comments on an accident that occurred at the Silverstone Grand Prix in England in July 2021, he refers to Lewis Hamilton with contempt multiple times, without even mentioning the English driver's name, referring to him only as the word, and also engaging in homophobia when commenting on the 1982 season, stating that the redacted must have been giving more ass back then. In short, the defendant, a leader and exponent, I'm assuming you meant export there, of Brazilian sports, in an explicit display of racism and homophobia, simultaneously violated the fundamental right to honor the black population in the LGBTQIA+ community. The main objective of this action presented here in general terms is to demand that the state judge order the defendant to adopt obligations to act consisting of equity measures and anti-racist and anti-homophobic practices, as well as the duty to compensate for collective moral damages. The right whose application is claimed in this class action is not that relating to the individual sphere of the Black English 7-time Formula One champion Lewis Hamilton, victim of racist and homophobic insults that materialize the disregard for honor and dignity, but the right of all Brazilian society not to be affronted by any form of racism and homophobia, both offensive to the general public, generate repulsion and indignation, which leads to the necessary application of the duty to repair the moral damage perpetuated against everyone, without distinction, through the serious violation of historically acquired fundamental values. You know what? Fuck it. I'm gonna promote this stream on Instagram as well. I just want to... How fucking petty do you have to be to post something like that, like, right as I start my goddamn stream? Like, that in it of itself is so fucking petty. I'm still, like, at a loss for words at just the fucking audacity of her. Oh my god. Yeah, it's kind of sus. Yeah, it's very sus. And like, IDK could be unrelated. It could be, but also I've been advertising this stream for like the past while, for the past week, so I don't know, man. Another one? Well, let me finish my fucking Instagram ad first. Yo, please let me finish my goddamn Instagram ad. Oh my god. Okay. Let me take a look again. She's certainly trying. This is way past coincidental. It is. Actually, I dare y'all to send her a link to this stream just to see what would happen. Because, you know, that would be kind of funny. Why don't you try and do that? Anyway, where the fuck were we? Okay, here we are. Legally showing which articles are calling upon and how the associations of the situations fit into these articles, giving them right to sue. Okay. The facts. So we can just skip all of this. This is just all legal shit. Which basically shows how they have precedent to sue. Thank you for translating again, Mia, and for skipping the parts that honestly don't matter, because I don't want to just go into a legalese description. Anyway, there is no way this shit is coincidental anymore, so let's keep going. In November of 2021, the YouTube channel Inerto broadcast a video that circulated again on June 26, 2022, when it gained immense repercussion in Brazil and the world, causing great indignation in the midst of national and international means of communication and on social media. In this video, the defendant, Brazilian three-time world champion, former Formula 1 driver, it says pilot here, but from my understanding, the Spanish-Portuguese word for race car driver is piloto, so it means driver. It's supposed to say driver, but that's just how the language works. In an interview to the journalist Ricardo Oliveira, refers to the black English seven-time Formula 1 world champion Lewis Hamilton in a racist, humiliating, and vexing way. This is piloto/driver. Yes. Thank you, Elena. Vexing way. Without even citing Hamilton's name, calling him only, we are not saying that word again. The redacted moved the car and didn't let Verstappen avoid it. Redacted put the car there because there was no way of letting two cars go by in that curve. He did Brazilian slang word that means a perverse act, something done out of evilness or as a cruel joke. I'm assuming that's this. Sacanagem? What's like the closest translation to that in English? What's like... What is it, like the Portuguese equivalent of 69? Or like what is like the closest equivalent to that? I'm legitimately curious. His luck was only the other guy got fucked. He did a big fucking insert that same word again. The racist, insulting, and outrageous remarks occur in the context of the defendant's comments about the accident that occurred at the Silverstone Grand Prix. Not really, it's like generally trying to find one, but couldn't. It's like one of those words that doesn't have an equivalent. Okay. An accident involving drivers Lewis Hamilton and Max Verstappen and had negative repercussions worldwide. And I know I say this in like the main expose anyway, but this quote here, this is why I referred to the word as a slur, because it is clearly being used as such in this context. Like, I saw the debate about, is it a slur, is it not, but like, it's clearly being used offensively in this context, so why are we arguing about this? Like, there's a difference in saying, like, what the fuck is going on, and what is going on, you fuck. One of those is directly addressing someone with the curse. That's kind of the comparison that I came up with the situation, but again, it's being used as a slur in this context, so a slur, we will treat it as such. The racist, insulting, offensive, outrageous remarks, yada yada. The defendant himself admitted to having said what he said when he formulated a poorly constructed apology, saying that the word is used colloquially in Brazil as guy or person, thus minimizing the racist and pro-slavery connotation of the term. It is important to immediately recall, regarding such a shabby apology from the defendant, the analysis of Gelima Ribeiro in an article in the newspaper Folha de Sao Paulo on June 30th, 2022, according to which, in fact, white people, and I'm referring to everyone from all political persuasions, not just the former Brazilian driver, a staunch supporter of the country's current president, then Jair Bolsonaro, feel comfortable reading racist in Brazil and widely use the words. We are not saying those words. However, as continues, these expressions are not synonymous for person, since the marking of the other is precisely a way of dehumanizing the interview itself. While Hamilton is just redacted, there is no little white guy to refer to a white driver, and it's important to emphasize that the use of redacted is always to highlight something negative. The gravity of what occurred was immediately recognized in sports circles, to the point that Formula One decided to ban the former driver from the so-called paddock of the category's races. The paddock is the area that houses the teams, vehicles, race officials, and guests during races. Furthermore, Formula One and Mercedes, Hamilton's team, published statements on June 28, 2022 condemning racist and discriminatory remarks against Lewis Hamilton. Although they did not expressly name the defendant and former Brazilian driver in the statements, both highlighted the seven-time English champion's efforts to combat racism and increase diversity in the sport. According to the Formula One statement, discriminatory or racist language is unacceptable in any form and should not be part of society. Lewis is an incredible ambassador for our sport and deserves respect. His tireless efforts to increase diversity and inclusion are a lesson for many and something we are committed to in F1. Mercedes affirmed in turn that they condemn in the strongest way any usage of racist or discriminatory language of any kind. The FIA, who regulates the sport, posted the following message on social media. The FIA strongly condemns any racist or discriminatory expression which do not have a place in sport or in society. We provide our solidarity to Lewis Hamilton and support to his efforts towards equality, diversity, and inclusion in motorsports. Oh my god, the term used in the stories are bullshit, sorry, but that is such a blatant lie for sympathy. It absolutely is. Like, we all know he meant it as a slur. He fucking meant it as a slur. And as such, it's a slur. However, the defendant and Brazilian ex-driver did not limit himself to the racist French, incurring as well in homophobia. Just a quick note, with legal documents like these in general, this is kind of just, they tend to like repeat themselves a bit. So this is perfectly normal for a document, especially one where they are calling for action to happen, and yeah. According to a UOL report, another excerpt of the fast-paced and nauseating interview released on June 30th, 2022, the defendant asked about the 1982 season, as well as what he thought of that year's champion, Keke Rosberg. In response, he claims that Keke was a piece of shit. He then compares Keke to his son, Nico Rosberg, the 2016 Formula One world champion. Keke, he was a piece of shit. He had no value. He's just like his son, Nico. He won a championship, the redacted Hamilton must have been giving more ass back then, so he was kind of bad. According to the Folha de Sao Paulo newspaper, the excerpt was reproduced by the Grande Primo portal, and the interview was originally given in November 2021 to a YouTube channel called Motorsports Talks, which has since removed the video. Folha reports that in the first part of the interview, the defendant calls Hamilton the slur twice. Folha de Sao Paulo newspaper reports that the PSOL, Partido Socialism, the Socialism and Liberty Party, thank you, Mia, for translating that, and the Chamber of Deputies reported the incident to the Federal District Public Prosecutor's Office and of the territories, accusing the former driver of committing a crime of discrimination or prejudice. The videos of the defendant's hasty and nauseating interview were widely broadcast by national and international media and had enormous repercussions in Brazil and around the world, triggering a serious wave of revolt and indignation throughout Brazilian society, as well as immense international repercussions. The articles mentioned below illustrate the enormous decimation achieved by the defendant's racist and homophobic remarks. And then these are translations to some of the articles. Nelson Piquet apologizes to Lewis Hamilton, says it was badly thought. In this context, badly thought would be used when you're using the wrong word for what you want to say, or saying it to the wrong audience, not in the sense of his thought process being wrong. Thank you so much for the context, Mia. Piquet offends Hamilton, uses homophobic expression in new form of interview. An ad. God damn it. I'm not gonna punish the Twitch viewers or the YouTube viewers for ads popping up at the worst possible time, so we might pause momentarily for the ads to end. Okay, ad over. So a lot of these are just articles from around the world and whatnot. Oh, all of the English language ones. And the French. The Germans too. 7. Dignity of the human person, structural racism, and homophobic violence. The offensive, humiliating, and vexatious remarks of racist and homophobic nature, publicly uttered by the defendant, a 3-time Formula One champion former driver, therefore a public figure and representative of Brazilian sport, against the English black driver, 7-time Formula One champion, through the outrageous and nauseating interview given to a sports channel on the internet, violates at least 2 systems of norms, both considered fundamental in the principled framework enshrined in the federal constitution. Namely, the norms that protect the honor and dignity of the human person and the norms that protect the black population against racism. Here, racism is referred to as a veiled practice, which does not need to be revealed verbally and explicitly, because it almost never is, but which resides in the way social phenomena reproduce themselves, guided by the social structure on which they are based. As Professor Silvio Almeida aptly describes it, we can say that racism is a systematic form of discrimination that has race as its foundation, that manifests itself through conscious or unconscious practices that culminate in disadvantages or privileges for individuals. Yes, I'm back, and, we have gone into some weird shit. Depending on the racial group to which they belong. Thus, it is not necessary for the offense to be expressly derived from hatred or racial discrimination in order to recognize its racist character. It is sufficient that it reveals itself as a reproducer of the systemic violence that demonstrably fails Afro-Brazilian descendants. When one bears in mind that structural racism constitutes one of the main marks of our social organization, it is necessary for the judiciary power to operate towards dismantling this structure, replacing the practices on which it is founded with affirmative measures of another public configuration. It is Silvio Almeida, again, who provides elements for this reflection. Conscious that racism is part of the social structure and therefore does not require intention to manifest itself, although remaining silent in the face of racism does not make the individual morally and or legally guilty or responsible, silence certainly makes them ethically and politically responsible for maintaining racism, Max! The change of society is not achieved only through denunciations or moral repudiation of racism. It depends above all on taking stances and adopting anti-racist practices. Such anti-racist practices alluded to by the celebrated author are in no way mistaken with incitement to counter-violence or racial hatred. On the contrary, it is about giving concrete expression to the fundamental precept of the dignity of the human person, enshrined in Article 1.3 of our Constitution. It is a matter of uncovering the structures of racism, which here is not seen as a moral vice, but as a benchmark incorporated into society, consciously or not, over the centuries and which contaminates the economy, politics, and law. As for homophobic violence, the situation is of similar gravity. As Marcelo Sequeira from the gay group of Bahia points out, if there is no law in Brazil that punishes homosexuality, there are also no laws that guarantee rights. If on the one hand, there are no laws that make homosexuality a crime, then on the other hand, there is a veiled discriminatory culture. There is no punishment in the law, as in Muslim countries, but there is a culturally ingrained homophobic practice within our society transmitted by families, churches, public and private institutions. It is taught in schools that gays, lesbians, and I don't feel comfortable saying that word, though I'm sure that's just the English translation of the word that was originally Portuguese, are second-class citizens. This view is strengthened by opinion leaders who promote defamatory campaigns against homosexuality. Today, in Brazil, discriminating against homosexuals has become popular entertainment, and punishing this popular activity is the most difficult and complex thing with the current legislation. There is a lack of humane treatment in police stations where gays are afraid to file a complaint. Discriminated homosexuals cannot even appeal to the bishop. Excuse me, sorry. Given the testimonies of these representatives of the Catholic Church, it is necessary to become conscious that defending the civil rights of homosexuals is a process of civility, and guaranteeing those rights should serve to improve relations between people and preserve all the diffuse and collective rights of humanity. Violence against this segment begins early. At home with family, at school with teachers, thank you for subscribing, and the student community, at college, at work, on the street, everywhere. No place is safe for a gay, lesbian, or, not saying that word. The crimes committed against this segment range from insults to physical extermination. I have to make the difference between transgender and that word in the document, so I use that as well. Yeah, I figured that was the case. Doesn't make the word okay to say, though. At least from my experience. The data of homophobic violence compiled in the 2021 report from the gay group of Bahia were terrified. At least 300 LGBT people suffered violent deaths in Brazil in 2021, 8% more than the previous year. 276 homicides and 24 suicides. Brazil continues to be the country in the world where the most LGBT people are murdered, one death every 29 hours. The data is based on news published in the media, collected and analyzed by the gay group at Bahia, which for 40 years has been divulging these sad statistics, demanding public policies from the government that eradicate this carnage that goes far beyond these numbers, as they represent only the tip of an iceberg of hatred and blood. Okay, it looks like we have 60 people in stream now on all the platforms. We've been on this for about 46 minutes. So we're gonna switch gears a little, because while this is interesting, as I said, this isn't the only finding that I made. So I'm going to hide my display capture for a brief moment, because I found some very like batshit insane legal things. Like, for example, did you know that Junior sued the government over a broken bottle of perfume? I'm not kidding, and I am pulling up the shit right now. Ugh. Clean up by name. Like, I have a lot of documents. Again, these are all like, I got these through like the Brazilian court case lookup. So these are very easy to find. I just don't remember which one I named. Oh yeah, I named a perfume gate. Because it was so fucking stupid. Okay. Give you like a moment, y'all. While I take care of this. And now I gotta get the translations up. Give me a moment, y'all. I promise it's gonna take a bit. Just cause I gotta have the translations and the originals side by side, just so y'all know I'm not making this shit up. Metaphorically. Next translation is... You know, this is a good time to share the stream and have more people come in, because I want you to share this with your friends, share it with your enemies, share it with your priest, share it with your rabbi, because shit is about to get pretty fucking psycho here, and I can't wait to show y'all what I found, because I swear to God, y'all, it's been such a fucking crazy week. And I cannot wait to share with y'all some of these findings. Like this perfume one. Just give me like a bit longer just so I can get the translation in. And open translation. Now at this point we're going to get into machine translation, so it won't be 100% accurate, but I didn't want my friend to like have to translate 2,700 pages of legal bullshit. And are the Piquets even known outside Brazil or even just F1? Fuck if I know, man. I don't know. But what I want to show you next is the time Nelson Jr. sued the Brazilian government, well, specifically the National Treasury, or whoever the fuck runs Brazilian customs, over perfume. So, this lawsuit in particular was filed back in March of 2025, and it only got resolved in July. And it was only very recently that this actually ended up on the database, as far as I'm aware. But I want to show y'all the ruling in particular because it shows just how stupid this is. So at this point, I'm going to start filming myself recording it because holy shit, this is one of the things where you have to like see it to believe it. All right, here we go. I'm gonna zoom in a little on these. This is a lawsuit filed by Nelson Angelo Piquet, Nelson Jr., against the union, seeking to compel the defendant to pay compensation for material damages in the amount of over 4,800 Brazilian real, which is about $900, I think. I might be wrong. The plaintiff states that they traveled to the United States of America and, upon returning to Brazil on June 8, 2024, had their luggage inspected by customs at the Guarulhos International Airport, at which time a customs agent allegedly damaged an imported perfume from the Tom Ford brand, Jasmine Rouge model, valued at over 4,800 Brazilian real. It alleges that the fact was recorded in the goods retention report number, not saying that number, drawn up by the inspector himself, and that, after the event, a request for reimbursement was submitted to the Brazilian Federal Revenue Service, which was denied on the grounds that the damage resulted from the traveler's sole fault, who allegedly stored the perfume, quote, among the clothes loose and outside of the original packaging, making it impossible to foresee that it was a fragile object. So there's like a lot you can take away from this because, again, this dude literally sued like the revenue service over fucking perfume. And there's just, I'm at a loss for words here. Jasmine Rouge is one of the cheaper bottles too. OMG cringe. It gets better. It gets better. Like, ultimately, Junior wins this case, but it's just the fucking audacity of it that fucking sends me. Are you live on more than one site or something? Yes. I am live on multiple sites, but I'm also advertising my shitty ass stream on Instagram because why the hell should I not? It's my stream. I do what I want. The union, in its defense, alleges that there is no liability since the Federal Revenue Service has self-verified through video footage that the perfume was improperly packaged, loose, outside its packaging, and among clothing, thus establishing the plaintiff's sole fault and breaking the causal link. It argues that the agent acted regularly in the exercise of customs police power without abuse or excess. Subsidiarily, it maintains that the plaintiff did not prove the value of the damage, presenting only an internet link, without an invoice or proof of purchase, which makes it impossible to determine the amount of compensation. I could understand if it's whether the canter bells, but there's no way to see them traveling. Thank you for saying I deserve more spotlight. You know, nothing's stopping you from, like, sending this to just all the F1 journalists. You can just send them, like, hey, this random bitch in Louisiana is reading, like, all these lawsuits the Piquets were involved in, and they're financial parasites. She has the paperwork to prove it. And once this stream is done, I'm going to be uploading all of these documents up on the internet for free use by y'all and anyone else who wants to use it. Because, you know, freedom of information. Therefore, it requests that the action be dismissed. The question is whether the union has any responsibility in relation to the event described. Indeed, the yada yada, this is all the legalese. Again, what are the legalese? In the case under analysis, it remained uncontested that 1. The authorized baggage inspected by customs officials at the airport, 2. During the at customs conference, a perfume belonging to the plaintiff was damaged. 3. The plaintiff himself, the officials in charge of the inspection acknowledged the damage in the property retention report. Which, yeah, the perfume was damaged. Furthermore, the union itself, in its administrative pronouncement, acknowledges expressly, stating the occurrence of the damage. On June 8, 2024, Mr. Nelson Angelo Piquet landed at Sao Paulo International Airport. During the customs conference, the Tom Ford Jasmine Rouge perfume was damaged 100 milliliters. Therefore, the 3 elements of responsibility have been demonstrated. Objectively, namely, administrative conduct, customs inspection carried out by an agent, occurred during and as a result of the carried out by an agent public. 2, damage, perfume damage during inspection. Finally, 3, causal link. The damage occurred during and as a result of the inspection activity. The union alleges the victim's sole fault as an exclusion of liability, arguing that the perfume was improperly packed in the luggage, loose outside its packaging among clothes, maintaining the plaintiff caused the damage by not adequately protecting the item. However, this argument does not hold up. To establish the exclusion of fault solely attributable to the victim, it would be necessary to demonstrate that the damage resulted exclusively from an act of the individual, without any participation from the conduct of the state agent, completely breaking the causal link. Furthermore, the claim that it was not possible to foresee there was a fragile object among the clothes does not absolve the state of responsibility. when conducting physical baggage inspections, the possibility of encountering fragile, valuable, or sensitive items is inherent to the activity. The public agent must conduct the inspection with due care, otherwise, failure to do so will generate objective liability for the state for the damages caused. It should also be emphasized that the victim's exclusive fault would presuppose that the damage resulted solely from the individual's behavior, without any contribution from state conduct. In the case at hand, the damage was caused by the public agent's action during the handling of the baggage in the exercise of customs inspection. Even though the perfume lacked special packaging, the damage did not result from the packaging itself, but rather from the way the agent handled the baggage during inspection. The causal link exists between the agent's conduct, handling the baggage, and the damage, breakage of the perfume. If the perfume had been broken before the inspection, or if it had been damaged on its own due to inadequate packaging during transport, one could consider the victim's exclusive fault. However, the damage occurred during the inspection, due to an act of the public agent, as recognized by the union itself. It is therefore clear that in the present case, the plaintiff's exclusive fault has not been demonstrated. What is evident is that the damage occurred during the exercise of the inspection activity and is attributable to the conduct of the public agent who, while handling the baggage, caused damage to the private property. Finally, the union subsidiarily questions the amount of damages, alleging an act of documentary evidence, invoice. However, the union itself, in its administrative statement, did not present any concrete evidence to refute the amount indicated by the plaintiff. On the contrary, it merely alleged generically the insufficiency of the evidence, without, however, indicating a different value or presenting counter-evidence. In this context, and considering that the union acknowledged the damage but did not specifically challenge the value indicated in the final claim should prevail. In light of the foregoing, I rule in favor of the plaintiff's claim against the union and hereby order the union to compensate the plaintiff for the material damages in the amount of 4,800 real, which is, again, about $900 in modern money. Modern U.S. money, that is. Which shall be adjusted for inflation and interest from June 8th, 2024, according to the indices set forth in the Federal Court's calculation manual. No costs or fees, yada yada. That's the end of it. So, I also have like a timeline of the case being filed. Because it especially fascinates me that this originally happened in like 2024. Late 2024. But, mid-2024 actually. Mid-2024. But, the filings themselves don't actually start until 2025. Like, over 6 months later. Like, what even is the point? Because when it costs more to sue than when he got back in the suit? Exactly. That's what I'm trying to say here. Like, what the fuck is the point of getting that money? Just buy a new perfume, dude. You have the money to buy a new one. Like, shit happens. Shit gets broken. Like, Jesus Christ. What the fuck is wrong with you, dude? Anyway, that happened. It's an ego thing. Yeah, it's very, very likely an ego thing, just doing shit because you can. So, what do y'all want to see next? Do y'all want to see a Kelly lawsuit? Because I found a couple of Kelly lawsuits, and they get very interesting. All right, give me a moment. Let's do this one, yeah. While I take care of this, I'll tell you, like, I wrote myself some, like, notes for each of these lawsuits. Just to kind of, like, make sure that I take everything and to make sure that I have, like, everything together. And, this is the bottom line I had for the Nelson perfume case in particular. This case is a perfect example of the Piquet family's litigious insanity. They'll sue over anything, even a fucking perfume bottle. Well, Junior scored this pathetic victory is just another drop in the bucket of their legal terrorism. Meanwhile, his sister Kelly is shaking down nail salons for $288. We will get to that lawsuit in a moment. And his dad, Nelson Sr., is facing million-dollar lawsuits for being a racist homophobe. The apple doesn't fall far from the tree, but in this case, it's a rotten, money-grubbing apple that reeks of desperation. Keep wasting the court's time, you fucking leeches. Yeah, let's do the nail one first, because the other one is going to take a little bit of explaining. So it's these files, I believe. Open with Vivaldi. And now I gotta get the translations in. Oops, these were not the files I wanted to open. These were the files I wanted to open. Did it just default to? Lovely. So which one's 1 and which one's 2? I guess I'll have to do one at a time. Sorry, like, I gave these, like, specific file names, but my browser has refused to acknowledge the names that I gave them, so this might take a moment so I can remember which file is which. And there were, like, 3 files associated with this particular lawsuit. Do I know if Kelly or anyone else involved has seen it? I like to imagine she has, but it's like, that's one of the things you can't really, like, control. If that makes sense. So, nails 1 is here. Okay, there we go. Split. Split. No, that's not how I wanted to split it. No! These two split. These two split. And these two split. Anyway, we're now going to talk about the time Kelly sued a nail salon for like $300. And yeah, because she did that. And I honestly... It's just so fucking pathetic, y'all. Like, I want y'all to see how fucking petty this family gets. So I want to start off with, like, a timeline of the, case in general before we actually moved on to the meat of it. So... And I'm gonna open up my Instagram again to share this because holy fucking ass shit. Sorry, I had to respond to a message real quick. So, this was a lawsuit that happened in 2016, and small claims. She sued a nail salon, like it's called Lilac Nails Beauty Salon. That was the name of the fucking salon, and fuck, man. And this goes on for like a little bit of time. So I just wanted to give you a brief timeline of what actually happened before we get into the meat of this situation. So, give me a moment. Let me grab my notes. Let me put the notes back up again. So this is a special civil court procedure, a procedimento de juizado especial civil. I probably butchered the shit out of that translation. I apologize profusely. It's a civil liability case for the most pathetic fucking small claims shakedown imaginable. This is the court for people who spill over like spill coffee and shit. So, plaintiff Kelly. Defendants Lilac Nail Salon del Basilia Limited, initially then dropped. The main target was, I think, the original owner of the nail salon company. I'm not quite 100% sure. The people who owned the place were definitely sued. So, here it is. Here is, like, the core drama in this case. And I'm going to turn on my Instagram for this. Sorry, like, again, I have my notes on, like, another screen. So, this is the instance where Kelly sued a fucking ass nail salon for under $400. She decided to drag a fucking nail salon through the legal system over some trivial bullshit. I tried to figure out what it was, but it required you to log in to find out the specifics, which I don't have an account. But it was so minor that they reached a settlement immediately. The exact complaint isn't even worth detailing. It was that fucking petty. So all of this is just like them trying to figure out who gets it, who is going to like have to deal with this suing, and all of that nonsense. I'm gonna put... Sorry, I'm just doing all my Twitch and shit nonsense. Looked at other former exhausted gets an XP battle and reach her live and hold for messy past. Which one? I'm curious now. Anyway, I just wanted to show this was indeed so petty that it immediately resulted in a fucking settlement. So everything is various petitions. Finally, the trial comes in and a settlement is reached almost immediately. The actual timeline for reference is on February 15th, 2017, right around here, they reached a deal where the salon would pay Kelly about 1,600 Brazilian real, which is about $288 US, just to make her go away, essentially. The salon actually deposited the money with the court like responsible business owners. But here's where it gets interesting. Here is where it gets interesting. Because like, as I told you, the business deposited the $288 like normal people. But Kelly's legal team was so fucking incompetent that in April... Well, not exactly April, but... So, where the fuck was I? The business deposited the $288 like normal people, but they fucked up so badly. They were so fucking useless. The court had to initiate a peliderado vesal pena de... I can't pronounce that. for the last time under penalty of extinction so they could file the fucking paperwork to collect the fucking money. She nearly got the case dismissed because she couldn't be bothered to collect her winnings. Like, look at this. Contrary to the defendant's claim, the power of attorney on page 58 is granted specific powers assigned to... Like, they just had to, like, repeatedly yell at these people to fucking get the money. We agreed on the settlement. Just get the fucking money already. And this goes on for a very long time until, like, July, August-ish 2017 when they finally filed the fucking paperwork. And, again, this is just a fucking nail slot. We don't know what happened, but it could have been significant. This was under $300. And even then, I don't even know what to say, man. Like, there is nothing in here that warrants actually suing this fucking business. And I'm just at a fucking loss for words. I genuinely don't even know what to say about this. Aside from, you know, the obvious. When normal people are bored, they watch the show or something, but I guess the Piquets are bored, they waste government resources. Yeah, probably. So let's keep going. I actually found some of the paperwork involving these proceedings, and that is not the translated version. Can y'all do anything right? Okay, this is correct, the correct one. And then this is the correct... No, that is not the correct one. The correct one is this one. Sorry, I'm just trying to finagle my resources here. Ugh. So those two are correct. And then this is 36994. That would be nails 2, I think. Yes, it is. That is nails 2. So this is the second document pertaining to the incident. Sorry, y'all. Just trying my best to, like, get all of this in. All right, so this is the first proceedings regarding this piece. So this is just like them agreeing to the settlement as far as I'm aware. Or something. Again, I'm not 100% familiar with how the law works. And this one... Is this just... Can I please get nails 2? Why are you not working with me right now? Uh, uh. I'm sorry, y'all. Like, I know I'm not necessarily in, like, the 100% happy-dappy position, but, like, I can't believe the audacity of this fucking bitch. Like, I legitimately, undoubtedly cannot fucking believe it. Like... Anyway, let's move on to, let's see what other lawsuits that I have at my disposal. We're just gonna take a short break while I try to figure out what the fuck's going on in my browser. I'll be right back. don't have it up, so basically, if you're just coming in or y'all were not here when what happened, immediately after the stream went live, Kelly posted an Instagram story claiming her daughter is a rainbow baby and also celebrated her and Max's 5-year anniversary or whatever, and reminding the child is 6 months old now. Now, I want to be clear, we're not here to question whether that miscarriage happened or attack a deeply personal moment. That is beneath what we're talking about today, and that's a really touchy subject. That's a whole nother can of worms, and that's just not something I'm interested in unveiling. However, what we are here to question is the timing of this announcement. Because remember, I've been teasing this stream all fucking week. We are well aware that the Piquet family is aware of my existence. And I'm here today, like, digging up all of these legal documents pertaining to them. So, there's not really much I can say that warrants appropriate saying. But I kind of just wanted to actually acknowledge it before we continued on with the translations. At the very least, just so we're all on the same page, and why I'm a little more subdued than you would assume I would be from finding out all of this cool new information. So, yeah, that's kind of what happened, if y'all missed what originally went down. And we still have a number of other lawsuits to go over, specifically regarding AutoTrack, the Piquet family business. Because, Jesus Christ, they are litigious as fuck. And, I I don't know, man. I guess I just wanted to acknowledge that, just talk a little bit about that before we continued on with the actual lawsuits. Because we have another Kelly lawsuit to get into, and holy shit, this gets interesting. So let me pull up these documents. Let me make sure that my internet browser is doing this correctly this time. Another one? Okay, so it looks like I gotta do these one at a time. That sucks, but we will do with that what we can. So I'm gonna show you the actual, like, legal proceedings first and give you, like, a basic rundown of what happened, and then we'll get into, like, the meat of it, the actual, like, documents and decisions. This I had to get through, like, a third-party website that posts Brazilian court cases instead of, like, an actual regular the actual, like, database, just because, like, not all of the databases on the Brazilian courts were reliably, usable, and it wasn't that expensive to get the documentation for this. It just cost me, like, I don't know, 90 cents. So we're gonna start off with this, the actual timeline. So remember that one time Kelly worked for Shirts? Apparently, that employment did not end on good terms, and we're gonna talk about it today. So, again, this is like a really long-ass time, like, cause like there were appeals that happened after this. Like, so much fucking happened. Like, the first recording of it is in March 2015 when it was distributed by lottery, and summons were heard. A lot of petitions on both sides. So, I'm gonna give you, like, a basic rundown of what happened first, just according to my notes at least. And there were actually 2 case numbers involved with this. The other, I believe, was just the enforcement, them trying to get paid. But here it is. Here is, like, sorry, I'm responding to a text real quick. So, here is the absolute core of the dispute. So, Kelly was hired to work opening the first Shirts shoe brand in New York. She claimed her employment started on June 26, 2012, but the companies only formally registered her in their books on October 1st. She was dismissed on March 4th, 2013. So the heart of the lawsuit is that she worked without proper pay and legal recognition for the period before her formal registration. But it gets a little more insane from here. And I can't wait to show you how insane it fucking gets. Because, like, this is a legitimate labor issue. Like, we are not here to argue that. But some of the things that she claims in this are so fucking fucked. I honestly don't even know what to say. So, let's start off with... Did I put these in reverse or regular order? 1. This looks like, this one is just the legal proceedings, I believe. Hang on, let me hide again. Nope, that is the wrong file. This is the file I wanted. Yes, this was the file I wanted. Okay. Display capture. Turn that on. Now you get to see the process in real time. Open translation. Okay. So now we can get into the meat of this absolute fucking insane lawsuit. So. Jurisdiction, enforcement, recognition of employment relationship, the jurisdiction of labor courts enforcement of Social Security contributions is limited to judgments and amounts subject to an approved settlement, yada yada, that are part of the employee's salary, transfer allowance. The case allows a single transfer that lasts until the day of contract termination. The permanent nature of the transfer and the consequent absence of entitlement to a transfer allowance have been demonstrated. The plaintiff's appeal is denied. Was this... Again, I'm just trying to make sure I have all of this in, like, the correct order. Because, like, some of these are just, like, completely, like, in a different order. And I just... Okay, these are in order. Okay. I'll spoil it right now. Kelly partially won this case, but as I said, shit's about to get weird. Employment relationship prior to registration. The ruling recognized the employment relationship between the parties for the period between June 26, 2012 and September 30th of the same year. Dissatisfied, the defendants appeal. They do so on the grounds that the factual and legal elements necessary to establish an employment relationship are not present during the period in question. They claim that the time of the company's store wasn't even operational, so that there could be no provision of services by the plaintiff as an employee. They also make a counterpoint regarding the non-occasional and habitual nature of the provision of services. Concluding, in fact, from this perspective as well, one cannot speak of an employment relationship. Judicial branch. Yada yada. The defendants are wrong. Initially, I know that the defendants admitted the plaintiff provided services to them during the period in question. However, they claim she did so as a self-employed individual, receiving a stipend. Therefore, based on this premise alone, it can be concluded that the fact that the store was not yet operational does not preclude the provision of services. Indeed, the plaintiff provided these services even though the defendants claim she did so as a self-employed individual, a circumstance, I note, that places the burden of proof on the companies to demonstrate the impediment to the right claimed in court. To resolve the controversy regarding the existence or not of an employment relationship, it is necessary to analyze in each case the presence of legal requirements contained in these articles. It is necessary to verify whether the situation is configured in which the worker, supposedly self-employed but habitually involved in the productive activity of others, despite having... some of this is cut off. Contribute a relative role regarding the work itself, has no control over the activity economic. It should also be mentioned that the existence of an employment relationship does not depend solely on the will of the individual and the contracting parties. There are elements foreseen by law. regularity, subordination, remuneration, personal nature, which, when present, authorize the recognition of an employment contract between the parties. After all, the employment contract is a real-world contract that emerges from the form and manner in which the services are provided, regardless of what was formally agreed upon between the contracting parties. In the case under analysis, although defendants repeatedly mention the factual and legal elements necessary to establish the relationship are absent, the allegation is flawed because it's generic and non-specific to the case. Yes, because the defendants do not provide precise context for what the plaintiff did before being officially registered in her employment record book and what she did afterward. In other words, it is not possible to verify the factual aspects that distinguish the provision of services within these different scenarios reported by the defendant. The companies mentioned objective good faith, private autonomy, and other broad issues, but these do not invalidate the presumption that the alleged independent contract previously signed underwent a profound alteration, subsequently transforming into an employment contract, as shown on pages 228-229. Again, we would have the evidence here, but this is all behind like a paywall or some shit. Note that the author began working as a coordinator in around June 2012. Marketing in June 2012. The document on page 74 clearly demonstrates this fact. It is an email not specifically refuted by the defendants in which the company's general manager, Ms. Molina, introduces the new colleague to the other employees. It's worth noting that transcription. Guys, I would like to introduce you to Kelly Piquet, our new marketing coordinator at Schutz USA. Please copy this in future emails related to this area. Thank you. In this first contract, it's crucial to note the author would perform the function of coordinator marketing consultant. In other words, exactly the same function that she later performed, but the formalities of registration in the Brazilian workforce. There is not a single piece of evidence that can prove otherwise to conclude in the opposite sense. The contract on page 126, translated to our language by means of a sworn translation, far from representing the autonomy alleged by the defendant, merely evidences the typical circumstances of an employee contract. I do not see that this contract can support the argument of autonomy of will or objective good faith, circumstances which, as already mentioned, were presented in the foundation of the defense's argument. It is pointless to argue that the worker was self-employed, that she agreed to do this or that, if the factual circumstances reveal that the work arrangements have already been the same before and after the formal employment relationship. I'm gonna post it on Instagram, then I'm back on stream. My phone is on mute, so that's why, like, you can't hear me, like, yapping away. Anyway. Finally, regarding the argument of the contingency nature of service provision, a certain logical, argumentative inconsistency in the exposition of the conceptual idea can be inferred from the appeal text. The defendant stated that the non-occasional nature of the work is evidenced by the fact it must be performed habitually, that is, continuously, which is exactly the case in these proceedings. What appears to be the case at this point is that the defendant acknowledges that the work was performed habitually, an assertion that contradicts what was stated earlier. However, even if we do not adhere strictly to the literal text, it is necessary to observe that in labor law, non-eventuality differs from the idea of habitually, and there is already an error in the premises used by the defendant. There are several theories addressing this issue of occasional work. These include the theory of discontinuity, which defines occasional work as discontinuous, fragmented work occurring dispersed over time with significant breaks in temporal spacing. There is also the theory of events, which posits that occasional work depends on a specific fact or event that gives rise to a particular work or service. Another theory is that of the purposes of the undertaking or purposes of the company, where occasional work is assessed according to the normal purposes of the company, so that the occasional worker is one who meets an exceptional need within the framework of the normal needs of the undertaking. Finally, authoritative doctrine refers to the theory of legal attachment to the service recipient, arguing that the occasional worker is not tied to a single source of work, unlike an employee who is restricted to one employer. The fact is that one should not rely solely on one theory to define temporary work. Combining the elements presented, we have as characteristics of temporary work, discontinuity of work provision, no legal attachment to a single source of work, with a variable plurality of service recipients, short duration of the work performed, and that the work relates to a specific determined and episodic event, and the... Fuck. Okay, anyway... There's no element that could demonstrate a lack of continuity of the work from June to September 2012. Similarly, it cannot be said that the plaintiff was hired for a single specific event, and considering the defendant's company's line of business, there is no doubt that functions such as the one performed by the plaintiff are essential to the success of the business enterprise. Finally, it is certain that the plaintiff was legally bound to the service recipient, and that itself contradicts the contract. Initially agreed upon, whatever. Again, it's going to look a little wonky because it's a machine translation. I do grievously apologize for that. In the case under analysis, I have no doubt that the plaintiff acted personally in the defendant's best interest, even as an employee, starting on June 26, 2012, so much so that the defendant acknowledged this to formalize the employment contract starting in October 2012 without, I emphasize, any alteration in the modus operandi related to the provision of services. I therefore uphold the first citizen's judgment that recognized the employee relationship, so they have to basically pay her for the work she did in that period of time because she was technically working for them at the time. But this is where it gets interesting. Thank you. And it's okay, we still haven't gone to, like, the big documents yet. We're right now just going over, like, some of the shit that Kelly and Nelson Jr. did. The calculation of the amounts resulting from the termination of the contract as decided in the first instance was correct, so that the decision of the lower court does not warrant amendment at this point either. Termination payment. At this point, the defendant's objections are partly justified. Contrary to what was decided in the first instance, I do not see that proof of payment of severance pay is given solely through the termination of employment contract. Of course not. The termination of employment contract is the instrument that serves to, in the cases provided for by law and together with other documents, to move funds from the linked work account and also to request unemployment insurance payments. It obviously serves under certain circumstances to approve the payment of the funds consistent to the contract termination. In any case, it is not the only document that could serve to prove this. Here, the defendant presented proof of deposit into the plaintiff's checking account in the amount of 13,925 Brazilian real, which is about... Sorry, I have to get my converter out now. About $2,600. Adjusted for inflation for 2025, so it was very likely different back then, but we're not going to go into the historical conversion rates right now. I'm really not in the mood for that. The plaintiff attorney acknowledged when testifying in court that she received this amount. Differences are due to the claimant, especially considering the period of employment recognized in court, with a direct impact on the calculation of the amounts resulting from the termination of the contract. However, there is no basis for applying the penalties provided in these articles of the law. There was therefore a well-founded controversy here, which led to the dismissal of these fines. The defendant proceeded to settle the amounts corresponding to the termination. These were the amounts it considered due, and did so within the 10-day period stipulated in Article 477. Therefore, one cannot speak of deliberate delay in the payment of severance pay. Similarly, there were no undisputed amounts to be paid at the first hearing. The fine provided is not applicable. I grant the appeal and exclude from the sentence the obligation to pay the stipulated fines for allegedly being late with the severance pay, because they were not late with the severance pay. Salaries without payment. The defendants argue that the decision ordering them to pay wages from the period from June 26, 2012 to September 30th, 2012 should not stand. They claim there is no basis for claiming wages during this period as there was no employment relationship. They further state that, with respect to the same period, the plaintiff received amounts as a cost of living allowance, totaling about 31,500 Brazilian real, which is in USD about $6,000. Okay. Thus, they maintain that any amount rewarded to the plaintiff would constitute a clear case of unjust enrichment. Regarding the subsequent period in which the contract was formalized, they argue that the documentary evidence, this demonstrates the payment of wages to which the plaintiff was entitled throughout the entire employment contract. They clarify that during this period of effective employment, the plaintiff demonstrably received in advance. Plaintiff received a bi-weekly payment, which is subsequently deducted from her total salary paid at the end of the month. They conclude that, stating that at the end of the employment relationship, no amount was owed to her. The defendants were not ordered to pay wages corresponding to the previous period, September 30th, 2012. Therefore, at this point, the defendants have no ground for appeal. The conviction, as revealed in the judgment on page 388, is limited to the payment of differences corresponding to the months of January and February 2013, and it must prevail since the documents do not prove the payment of the entire amount. Okay. So, basically, yeah. Just typical labor dispute, and we haven't gone to, like, the very insane part yet. These are just, like, the minor clarifications that the defendant, Schutz, has to deal with. So, continuing from here, this is another one where the appeal didn't get approved. The defense reiterated on appeal and argued that the plaintiff during the course of her employment contract held a management position and therefore would not be entitled to the overtime pay recognized in the first instance court. The claim that the plaintiff held a position of trust, thus placed in her position of trust, is unfounded. The law indicates the sole paragraph of Article 62 of the Consolidation of Labor Laws attempting to establish a more objective criterion to differentiate the employees indicated in star item 2, thus employees in positions of trust who perform managerial and supervisory functions who differ from other workers by standard are excluded from the overtime again under the terms of Article 62. Higher salary scale, the differentiated salary standard established by the legislator as a benchmark is effective salary plus 40%. Thus, the only employees mentioned the aforementioned legal provision, namely managers, directors, and heads of departments or branches, are not subject to the working hours stipulated. But the interpretation of this article must be restrictive. Here, it is understood the claimant was not a manager. She wasn't a director either, nor was she a department head. She was just a coordinator of marketing. She did, in fact, receive a very high salary, considering, in the words of the defendant's distinguished lawyer, the average salary standards of workers in this country. However, this is not what determines whether or not she is entitled to overtime pay. That would only be a factor if it were proven, which it is not, that the amount paid to the plaintiff was indeed 40% higher than that of employees working in the same department. But even if that were the case, the presence of other elements to rule out this application would also be necessary, the provisions concerning the duration of the workday, and here they are not included either. As stated, the law refers to an exceptional type of employee, one who manages, performs administrative functions, holds a high hierarchical position, and has powers that equate them to an employer. It does not exempt them from the general rule, those involved in technical and specific functions. The evidence shows the plaintiff only implemented marketing campaigns developed in Brazil at the New York store. There is no evidence of the records that the plaintiff could have hired, suspended, warned, or punished other workers. Furthermore, the plaintiff did not even have employees under her control. Okay. This is like the witness provided by the defense, just basically, again, saying like, look, she was not in a position of trust. You fuck off. Don't, like, try and, like, get out of trying to pay her overtime. Now, here is where it gets interesting. These are the clarifications the plaintiff, Kelly, wanted to make. The author that states such as the first sentence to make this decision left to determine the integration of overtime pay, night shift pay, and compensation under Article 71. The court ruling only addresses the termination-related aspects of the calculation of overtime pay. So, at this point, I think it should be... It should be acknowledged that, again, Kelly pulls some really weird shit in this document. And we're about to get into the very weird shit. Since the claimant understands that the unused break corresponds to payment in indemnifying nature, as she states in her appeal, there would be no basis for discussing integrations or repercussions. However, regarding the remaining issue, namely overtime, when addressing the topic under debate, which is the integration of impact of the bonus or other contractual payments, I do not see the relevance of the plaintiff appealing this matter. Let me explain. Determine the impact of a payment that has a wage-related legal nature or other benefits, it is necessary to know the calculation basis of the benefit receiving the impact. If the awarded payment is included in the calculation basis of another labor benefit, then the impact of the former is due on the latter. Here, the claimant's right to overtime pay was recognized. The overtime pay impacts the calculation of severance payments, including notice period, vacation pay, proportional salary, etc. In other words, they reflect, or as the claimant prefers, integrate. In this context, the name given is irrelevant, as it is all the same thing. Shakespeare would say, a rose by any other name would smell as sweet. No idea why they felt the need to quote Shakespeare in this, but okay. Therefore, I see no practical use of the claimant seeking integration rather than the related benefits. In this case, she lacks standing to appeal. So, basically... Kelly was trying to get compensated for meal and transportation vouchers, just benefits that she would have received in her role. But it's being rejected because she provided no documentation showing that she is entitled to these benefits. That is basically what's going on here as far as I know. Again, we're working off like Google Translate, so... Regarding the compensation authorized in the first instance, that's also not the case. The first instance decision reserves to be overturned. The author received the amount of 13,952 Brazilian real. This amount given the circumstances at the time which she was there. The fact that it was made available obviously refers to the settlement of the amounts resulting from the termination. The author may not know what this is about, but the defendant does, failing to author. Okay. Transfer fee. Now we're getting into the interesting stuff. Now we get into the interesting stuff. And I'm going to reapply my lip gloss real quick because we're going to start recording a bit because this is when it gets interesting. So the plaintiff, Kelly Piquet, claims she's entitled to payment of the transfer allowance since she signed a contract in Brazil and was later transferred to New York City. Article 469. Basically, The employer is prohibited from transferring the employee without their written consent for a location different than that resulting from the contract, not considering as a transfer that which does not necessarily entail a change of domicile. In turn, paragraph 3 of the aforementioned article of law stipulates that in case of need for service, the employer may transfer the employee to a location different from that stipulated in the contract, notwithstanding the restrictions of the preceding article, but in that case, the employer will be obliged to pay supplementary payment, never less than 25% of the wages the employee received in that location for as long as that situation lasts. Here, the plaintiff, Kelly, once again, Kelly Piquet, seeks payment of the transfer allowance, arguing that the contract did not provide for the possibility of transfer. She claims the transfer occurred solely at the defendant's behest. The author's claim, Kelly's claim, borders on bad faith. We are dealing here with a scenario in which there was a single transfer that lasted until the date of contract termination. The permanent nature of the change and the consequent absence of entitlement to a transfer allowance had been demonstrated. In this case, there is no basis for applying jurisprudential guidance. It is irrelevant whether or not there was a clause authorizing the transfer. The only condition that justifies receiving the additional payment in question is the temporary nature of the change. In this case, it was not temporary, it was definitive. Furthermore, and I consider this the fundamental point, the claimant admitted in her testimony, as seen in the minutes, that she was hired in Brazil to work in New York. So basically, she's trying to get compensation for moving from Brazil to New York, claiming that they transferred her without actually going through the proper legal process of transferring her, which the judge is basically calling her out for, saying it is not fucking true at all. She explicitly signed a contract for work in New York. So that's what they're saying here. Where the first store would open. Broadly speaking, there would be no need to even talk about transfer, since from the beginning it was foreseen that the services would be performed in New York. If that took a while to happen, slightly higher figure than expected was due to the delay in the store's opening. This does not alter the original condition initially foreseen that the plaintiff would provide services on site. Overtime, night shift pay, and holiday pay. Kelly Piquet intends for the work schedule described in the initial pleading to be accepted on the grounds that the defendant should have maintained formal timekeeping records. Since she had not done so, she understands the work schedule outlined in the initial pleading should be accepted in accordance with the guidance embodied in the summary. Initially, I know that the defendants at the store where the plaintiff worked were not obligated to maintain a schedule or to even formally monitor the working hours of their employees. This is because there's no conclusive evidence that more than 10 employees were working in the store. Furthermore, the provisions contained in this article, these are administrative in nature, and failure to comply will result in the application of the penalty stipulated in Article 75. Well, the author worked in a store in New York City, obviously in a foreign country. The company would not be obligated to comply with an administrative labor order, which has limited application to that national territory. I got another ad. I'm sorry, y'all. Just let me know when the ad is over and I'll start back up again. Okay. Ad is gone, y'all. Okay, we should be good. Yes, because labor inspection oversight is carried out by the executive branch, though the Ministry of Labor and Employment, its labor inspectors are responsible for ensuring respect for and compliance with labor regulations, including those of an administrative nature within the national territory. It's inconceivable to think that a national company operating on foreign soil could be fined for violating an administrative regulation applicable in Brazilian territory, especially given the sovereignty inherent to nation states. We haven't even gone to, like, the most insane part yet, y'all. Therefore, there was no obligation to record and monitor employees' working hours. This is not to say that the company should not observe the rules regarding working hours. That's not it. They were not required to keep a time card, and if they were not obligated, obviously there's no way to demand that they present them as a pre-established evidence in a legal proceeding. This falls within the scope of Brazilian labor law. So... I also know, also holiday pay. Here's the holiday pay bit. I also know with regard to holidays that the defendant did not indicate which ones were actually worked, so on this point as well, the first instance judgment does not warrant modification. Since the work was not proven to have been performed during nighttime hours, the plaintiff is not entitled to corresponding additional payment. So yeah, no, Kelly's not entitled to additional holiday or night hour pay because she didn't prove that she actually worked in those hours. Okay, this is the part I mentioned earlier. Transportation allowance and meal allowance. So, Kelly tried to sue for this, but the judge rejected it because she was not entitled to this as per her position. So we're gonna talk about this real quick. Yay! I noted at the outset that the author, Kelly Piquet, did not include the claim relating to these titles in the list of requests contained in the initial pleading. However, the claim and its grounds were included in the cause of action, thus characterizing what doctrine has come to call a misplaced claim. Even though the plaintiff did not formulate an express claim, she did so in the cause of action. It is therefore evident that there is no impediment in the initial pleading that would prevent the examination of the merits, especially since the defendant defended herself against these claims and did not even raise any possible issue of the claim's inadequacy. It is worth noting that in labor courts there is not the formal rigor of civil procedure with the principle of simplicity and informality prevailing, and there is no reason in this case to consider the claim under analysis to be unsuitable. By said issue resolved, there is no doubt that the request is doomed to fail. With regard to food, there is in fact no legal obligation, nor was there a contractual provision stating that the defendants would provide food vouchers to the plaintiff. And contrary to what the plaintiff in her appeal did not allege that the defendant in her defense had paid the debt in question analyzed. Regarding transportation vouchers, I believe the law governing this matter is that law that applies only to workers currently employed in Brazil, and that is not the case for the plaintiff. And I say this because that is what can be inferred from reading the provisions of the aforementioned law. And then he describes some of it. We're going to skip this part. Now, the plaintiff worked in New York. How can one even consider the applicability of said law in foreign territory, considering the specific peculiarities of public transportation in each country? How to compel a foreign transportation company to market transportation vouchers, making them available to Brazilian employees, even if it's argued that, in this case, no compensation would be due. In the corresponding case, the plaintiff has no better luck. The author did not even provide information about the transportation, route, and expenses incurred during the trip. Finally, it must be considered that the law stipulates that the employer is responsible for paying for transportation expenses exceeding 6% of the employee's basic salary. Now, considering the claimant's salary level, it is difficult to conceive that she would have had expenses for public transportation in that country, again, New York City, exceeding the percentage stipulated by law. Therefore, without further elaboration, there are several grounds to support the dismissal of this request. Now, this next one is damage to image, which was another claim rejected because no evidence was provided that the companies conducted themselves in a way that caused her moral distress or improperly used her image. But again, Kelly claimed it, so it is in the lawsuit and we must read it. Note that the author does not specifically address the grounds for dismissing the claim. The author, the plaintiff, Kelly Piquet. The judge ruled against the request, considering that there was no evidence regarding the use of the plaintiff's image in advertising campaigns. The document on page 127 would not allow this interference. Indeed, the use of an image without the consent of its owner, regardless of its intended purpose, constitutes an unlawful act, as it violates the individual's personal legal rights. Thus, the use of an employee's image for commercial purposes without prior authorization, even if no embarrassment arises, constitutes an unlawful act, resulting in civil liability for moral damages pursuant to Article 20. However, as the trial judge correctly observed, there is no proof that the defendant used the plaintiff's image in advertising campaigns. Such proof would be documented. It does not exist in the records. In the document on page 127 does not allow us to conclude that it is an advertising campaign. Moral damages. Again, we are now getting into like the actual insane shit. In fact, I do not see how the plaintiff could have suffered moral damages due to the mandatory use of the defendant employer's branded footwear. There is no proof of this obligation, but even if its use were required, it must be considered that the plaintiff was hired as the company's marketing coordinator, involved in implementing advertising campaigns and attracting clients. It would not be reasonable for her to show up for work displaying some footwear other than that produced by the company. A comparison is in order. Oh my god, he actually did a comparison for this. Oh my god. It would be completely strange and unreasonable for Volkswagen's marketing coordinator to visit clients using a Ford vehicle, or for Apple's marketing coordinator to circulate in different media using a Samsung cell phone. It is not possible for either party to come to court claiming moral damages for using products manufactured by their respective employers, especially considering the function for which they were worked in and they were hired for. In this context, considering that it is a renowned women's footwear brand, it would be unjustifiable and strange for the plaintiff to use footwear from a brand other than that of the defendant. This request merely reveals the deception inherent in most claims for moral damages filed in this specialized court. A large portion of the lawsuits include a request for compensation for moral damages. The arguments are extremely varied, but what matters, and what should serve as a guide for the judge, is that mere displeasure, annoyance, or hurt feelings are not sufficient to support a claim for compensation for this type of damage. To acknowledge moral damages to a person because they were restricted to wear the footwear of the company that hired them would be to relativize morality itself excessively. Perfect. Perfect. It would be absurd to admit that the circumstances described in the initial narrative could by themselves cause the moral distress the plaintiff claims to have suffered. Furthermore, I reiterate, considering that this is the person responsible for implementing the company's advertising campaigns, and it makes no difference whether the plaintiff, again, Kelly Piquet, paid for it or received the shoes for free, especially considering the plaintiff's high level of remuneration. If she felt she couldn't have paid for the product, she should have requested reimbursement of the expenses incurred, and to do so, she would have had to demonstrate the relevant expenses, which, as the judge of first instance correctly reserved, she did not. The request is doomed to fail. Hang on, I'm gonna take off my blazer. Health insurance and life insurance. Oh, we're about to get to the really good parts. Oh, we're about to get to the really good parts. I cannot fucking wait. I cannot fucking wait. Health insurance and life insurance. The author is also wrong on this point. Kelly Piquet is also wrong on this point. Legally, employers are not obligated to provide health insurance to their employees. Therefore, the plaintiff is not entitled to the benefits sought in this action. With regard to life insurance, the plaintiff would fall under the provision of Article 2, Item 3 of law that since she was hired in Brazil to provide services abroad. And if that is the case, the revisions of this Article 21 of the same law are applicable, meaning that the company would be required to take out life and personal accident insurance. This, however, does not entitle her to take out the policy. Only the heirs would be entitled to the life insurance payout if the plaintiff had died, which, fortunately, that's not true. It didn't happen. Okay, we're getting into the very juicy stuff. Official document, false testimony. One of Kelly Piquet's witnesses gave false testimony, apparently. And we're going to break that down. The trial judge, understanding the witness presented to the court, this isn't translated correctly. Give me a moment. Don't you just love Google Translate, y'all? The trial judge, understanding that the witness presented by the plaintiff lied in court, ordered the issuance of an official letter to the public prosecutor's office for investigation of perjury. The witness presented by Kelly Piquet lied in court. In light of this decision, Kelly Piquet expresses her disagreement. In summary, it states that such a measure is unjustified and that the situation will result in the violation of the right to a fair trial. Well then! The claim of denial to the right of defense in this case is completely unfounded since the plaintiff produced evidence and there was not a single moment in which she was prevented from doing so, and a procedural instruction conducted in a very satisfactory manner by the judge of first instance as revealed in the attached hearing minutes. In any case, I see that sending that official letter is not necessary. As seen, the witness, Ludiana, presented inconsistent and decontextualized testimony based on the factual premises under discussion in the case file. However, the question remains, did she lie deliberately? I don't think so. Basically, the witness that lied under oath is getting away scot-free because the judge here assumed that the witness was just nervous. Which we'll never know the truth of, but the fact that, like, he was referred to the court in the first place, or she was referred to the court in the first place, is fucking hilarious. There are many issues under discussion in this process, permeated by a context of determinacy, working hours, and circumstances related to the contract, as well as points to whatever. While the responsibilities inherent to the plaintiff's position are not presented in perfectly clear outlines, none of this is evident. I'll give them the benefit of the doubt. The witness was mistaken on several points. Nervous, as often happens to many who present themselves as collaborators of the court in the search for the real truth, she gave testimony that contributed nothing to the resolution of the case. So, her testimony was worthless anyway, is what they're basically saying. Which is fucking hilarious. Judicial branch. Regarding the controversy, I don't see how it can be characterized as perjury. I request to reject the request to send official letters. The judges agree to partially grant the appeal of the defendants, Schutz, to exclude from the judgment the obligation to pay the fines provided in Articles 467 and 477 of the CLT, and partially grant the plaintiff's appeal to set aside the requirement to notify the public prosecutor's office ex officio regarding the potential crime of perjury. In all other respects, the first instance decision is upheld, including regarding the amount awarded in the judgment. Was this the one where there's, like, a very specific thing that I want to, like, bring up about this case? It's not in this document. I think it's in one of the later appeals, because, like, let me just give you a quick timeline of this case, according to my notes. Case filed March 3rd, 2015. She came out swinging in demands including every labor benefit known to man, as you've seen here. The perjury was exposed. Kelly's own witness got caught lying under oath, and we have a specific document that actually talks about this in more depth. We will get to that document. And then, point 4 we'll get to. That is also going to be in this next one. But it takes 6 years of litigation for them to finally, like, pay out. Like, all of this bullshit. So, let me see. That was flavor 1. The next one is just like a dumb appeal that's like not really relevant to the case. This is the one we really need. This case, this is like the original, this was the original ruling. This was the pre-appeal. And there is one section in particular that I want y'all to like keep an eye out for. We will get there. We will get there. I promise you, we will get there. Okay. On the 16th day of August 2016 at 5:31 p.m., the courtroom of this court, yada yada, Kelly Sylvia Piquet, claimant, that is her actual full name. I'm pretty sure that's an open secret anyway. No one cares. It's not like it's her CPF sentence. Alright, here we go. Kelly Sylvia Piquet, already identified the case file, filed a labor claim against Arezzo Industrial et Comercial SA and ZAC Comercio de Calzarios Limited. Also already identified, requesting the joint and several severe liability of the defendants, preliminary injunction, recognition of a prior employment relationship prior to registration, with correction of the employment record book and payment of the corresponding benefits, legal settlements, integration of salary differences, reimbursement of unpaid severance pay, transfer allowance and related benefits, additional pay for accumulation of functions and related benefits, overtime and related benefits, night shift allowance and related benefits, 100% additional pay for work on holidays, compensation for moral damages, compensation for damage to image, compensation for material damages, granting and maintenance of health maintenance, fines under this section of the CLT, the granting of free legal aid. We will get to that. That's the part I want you all to focus on, because we will get to that. That is going to be... that's like... I have been like waiting all week to tell y'all about this part. Like, it is so fucking funny what Kelly actually tried to fucking pull here. I promise you. Yes, and she lost this one too because some of these requests are wild. This is the original ruling. The first thing we read was the appeal, because both sides appealed, and it was basically an everyone loses in this situation. But her request is partially granted because it was determined that there was a period of time that she would have been entitled to that working benefits. But, again, she does not win all of this. At this point, she's getting fucking greedy. Alright, let's do this. The issues of official letters and the termination of attorney's fees, the case was valued at 230,000 Brazilian real, which is... The defendants filed a joint defense, arguing preliminary lack of subject matter jurisdiction and ineptitude. On the merits, they contest the claims, alleging in summary that there was no relationship. Okay. I fucking hate. Google Translate is always fucking shitty with these PDFs, man. Okay. Anyway, about 230,000 real is about 42,781 US dollars. So, make it that what you will. Employment relationship between the parties in the previous period that all amounts due were paid within the legal deadline, that there was no transfer, therefore the additional payment claimed is undue, the claimant performed a function covered by the exception of the overtime payment, that no overtime or related payments are due, that the claimant regularly enjoyed meal and rest breaks, the claimant failed to use transportation vouchers, that did not engage in any conduct capable of causing moral damage to Kelly, and the exposure of Kelly's image stemmed from the function she performed in was a mere act of liberality on her part, given she was responsible for social media. The claim for health insurance and life insurance was unfounded, as there is no legal provision or any agreement between the parties in this regard. The second defendant is merely a shareholder of the first. Oh man, holy shit. And that there's no basis for joint liability, that the claimant does not act in any way that... Also, the free provision of legal services is denied as it does not meet the legal requirements for such. And so this is just like the timeline of the actual event. But we'll skip that because that's important. We'll get to the decision. It's undisputed in the records that Kelly was hired in Brazil to provide services in New York. With the cancellation of President number 207 of the Superior Labor Court has established the understanding that the applicable legislation should be that which is the most favorable to the worker, yada yada. Thus, as there is no evidence in the records that the legislation in the place where the services were rendered was more beneficial than the Brazilian labor law, the latter is the only one applicable to the present case. Material incompetence, social security contributions, yada yada. Ineptitude to the initial pleading. There's no question of ineptitude. The initial pleading meets the requirements of the article, bringing more specific and defined requests, along with their respective immediate and remote grounds for the request. Furthermore, the defendants failed to demonstrate that they suffered any harm. From the testimony of the claimant's witness. This is where it gets interesting again, because this is, again, this is the witness who was initially referred to prosecution for allegedly lying under oath, but that was appealed. The claimant, Kelly Piquet, in her personal testimony, stated that she worked until 7 p.m. and that on 3 days of the week she stayed until 10 p.m. The witness brought to court by Kelly, in turn, stated that she remained working every day after her shift ended at 8 p.m. Furthermore, when questioned by the court about the claimant's duties, the witness stated that she worked in the store and Kelly worked in the office located below the store because there was a showroom there where she even took care of the marketing aspects of the store. However, after further questioning by Kelly's lawyer, the witness changed her statement. The statement to say that Kelly also worked as a salesperson when the store was very busy and also had to help organize the stock. It is therefore clear that Kelly's witness lied to the court. There's a clear interest in favoring Kelly with her testimony, not only by retaining it, as mentioned above, but also by declaring a longer work schedule than that admitted by Kelly in personal testimony. Therefore, Kelly's witness's lack of commitment to the truth sought in the case file has been established, and I disregard her testimony as evidence valid for resolving the dispute between the parties. And that's how she got referred to the prosecutor's office. Basically, this part is the judge saying, telling the company and its shareholder to fuck off. They're going to be charged together in this nonsense. The defendants acknowledge the provision of services by the plaintiff, Kelly, during the period from June 26, 2012 to September 30th, 2013. However, they stated that this occurred sporadically. That's an error. That's supposed to say 2012 and 2012. It's September 30th, 2012. However, they stated that this occurs sporadically and occasionally. Thus, in accordance with this article, the burden of proof rested with the defendants to demonstrate that the services provided by the plaintiff during the period in question occurred in the summer alleged by them in their defense. In personal testimony, the representative of the defendants stated that the plaintiff, Kelly, in the months preceding the registration of the employment record book, provided services to the defendants performing advisory services, marketing, customer acquisition, and activation of local mailing lists, thus acknowledging that there was no change to the task performed by the claimant after the registration of the contract in the employment record book. The emails attached by claimant on pages 74 and 96, whose origin was submitted by the representative, the documents as being for the defendants, prove the plaintiff was welcomed and introduced as a new member of the team without any reservations, which shows that the plaintiff was admitted, in fact, on the date mentioned on the initial statement. Furthermore, the defendant's witnesses, who was Kelly's hierarchical superior, confirmed the New York store began to be assembled 3 months before its inauguration in mid-September 2012, and the claimant began working for the defense on July 1st, 2012, which also corroborates the thesis of the initial petition and completely discredits the defense's arguments regarding the employment relationship in the period prior to the date of the claim. So this is like the one W Kelly takes. Like, she did work for that period of time and gets the compensation for that. But again, she starts claiming some really stupid shit. Furthermore, the testimony of the defense witness also proved the plaintiff, even though the store opened, was already performing the same function that she performed after being registered. Consequently, acknowledged the claim suit, it began labor justice. So basically, this is Kelly's 1W, where she actually gets the money for this nonsense. But this is where it gets a little interesting. Salaries paid and salary differences due. In her personal testimony, Kelly Piquet confessed that she received the amount of 31,500 Brazilian real, and that this payment referred to the salaries for the months of June to October 2012. For this reason, I reject the request for settlement of unpaid wages for the aforementioned period. Regarding the salary differences for the period of November and December 2012, the bank statements attached by the defendant prove that the plaintiff and months of question received the net amounts of 7,500 Brazilian real and 6,400 Brazilian real, respectively, there being nothing to discuss. Therefore, let's not talk about paying any difference in rejection to the period in question. I reject the request. However, with regard to the period of January and February 2013, it was responsibility of the defendants required to provide documents proving full payment of the respective salaries, responsibility which it failed to fulfill as the bank statements were never shown. It cannot be argued that the documents attached on page 236 would be sufficient to prove payment. The values contained therein are invalid since the aforementioned documents were produced unilaterally by the first defendant and do not in isolation serve as effective proof of settlement. Another ad. Sorry, y'all. Okay. Oh, the ads keep interrupting the worst parts. I don't know. They always interrupted, like, the worst possible fucking moments. And it sucks. Okay, we're back. Furthermore, the defendants failed to provide the court with documentary evidence proving that bank transfers the amounts indicated in the documents on page 236 would have been effective. The documents on page 65 also do not prove payment of the remuneration for the month of January 2013, as this document only proves the settlement with the proportional vacation for the acquisition period from October to December 2012. Since the defendants failed to pay the total remuneration for the months of January and February 2013, I order them to pay the respective differences for the settlement calculation, the amounts actually paid for the claim during the aforementioned period as per those documents. Added transfer. The reimbursement of expenses related to property rental. Now we're getting into the interesting shit. Here. In her personal testimony, Kelly confessed that she was hired in Brazil to work in New York City, where the first Schutz brand store would be opened. Therefore, it has been proven that there was no transfer since the provision of the services in New York/USA were agreed upon between the parties in the contract itself. Therefore, the payment of a transfer fee is not due. Even if that were not the case, the jurisprudence of the Superior Labor Court is to the effect where it's only on a temporary basis, basically. A condition that was not proven in the case file. Therefore, I reject the request to order the defendants to pay an additional amount for transportation, inference, and reflexes. With regards to expenses related to the property rental, the claimant Kelly did not produce any evidence to the effect that the respondents had agreed to cover such expenses. Indeed, the lease agreement attached to the case file by Kelly proves the mere rental of the property does not, in fact, provide any indication that the defendants agreed to bear the expenses arising from it. Furthermore, the emails attached to the defendant's documents reveal that Kelly, after being dismissed from the companies, sublet the property in question, a transaction that would not have been possible if there had been any interference or involvement of the defendants in the lease of the property. Therefore, I also reject the request for reimbursement of expenses related to renting a property. And then we already went over this overtime stuff. And that was like one of the few W's she had on this. Regarding the night shift premium, Kelly's claim is also without merit, as the work schedule now acknowledged and even admitted by her in personal testimony does not entitle her to the premium in question. I reject the request. It was incumbent upon Kelly to prove the performance of the task as described in the initial position as grounds for the request of the additional pay for accumulation of functions, a responsibility which, however, she did not exonerate herself, insofar as her only witness did not honor the commitment to tell the truth before the court, consequently invalidating her testimony. It cannot be argued that the photographs submitted by Kelly on page 127 would by itself be sufficient to convince the court otherwise, since that document in isolation does not prove the alleged work as a model. She tried to say that, like, they used her images for modeling, but she just provided, like, one fucking image for that. Nor that it was used by them in advertising campaigns. Transportation voucher, meal voucher. Regarding the transportation allowance, the claimant did not even bother to inform which route she used to go to work and return home, nor did she specify the amount spent on public transportation, which makes her claim untenable. Regarding the meal voucher, the claimant did not submit any documentation to the court proving the defendants had a legal or contractual obligation to deliver/pay the benefit in question. Unless otherwise stipulated, the claimant, Kelly, is not entitled. Thank you for subscribing. Moral damages. Damaged reputation. Material damages. With regard to moral damages, the burden of proof rested with Kelly, pursuant to Article 818 of the CLT, a task from which, however, she did not relinquish herself. The witness who brought the case to court did not honor the commitment to the truth, which is why their testimony cannot be considered evidence in resolving this controversy. Kelly failed to provide any proof of purchase of shoes from the respondent's brand, as was her obligation. The defendant's witness testified that employees were not required to purchase Schutz brand shoes, and that samples of the shoes were made available for employees to wear while working in the store, as well as that discounts were granted to those who wished to purchase the brand's products. Basically, Kelly is claiming here that she was forced to buy the shoes to wear at the office, even though that is absolutely not true. Regarding the alleged misuse of image, Kelly's claim is also without merit, insofar as the single photograph she submitted to the court does not by itself prove that she acted improperly. It was not produced in favor of the defendants, or was it used by them in advertising campaigns for the brand. Based on the foregoing, I reject the claims for compensation for moral damages and damages to reputation. Regarding the alleged material damages, there is also no evidence in the records that the defendants would have assumed responsibility for paying the amounts related to the rent of the property. The property was rented by the plaintiff in New York, but the property was rented by Kelly, which is why they cannot be held liable for obligations assumed exclusively by the plaintiff. Similarly, the fact that the first defendant exercised its pejorative right to terminate the employment contract with the plaintiff, even though the latter was bound by a contract. The termination of a lease in itself does not entail an obligation to indemnify. Finally, Kelly did not produce any evidence of the proceedings to the effect that the defendants had made her available during the period between the termination and the end of the contract lease agreement. I fucking hate Google Translate, man. The claimant requests that the respondents prove her inclusion in life insurance during the term of the contract, as well as the granting and maintenance of a health plan without, however, claiming any compensation in this regard. Defendants argue there is no legal, contractual, or conventional obligation to grant such benefits to the plaintiff, and therefore nothing would be owed to her in this regard. For the move of departure abroad until the return to Brazil, no compensation is provided, and for the event of non-compliance with the obligation. Therefore, although the email attached by the claimant on page 99 proves that the first... Basically, Kelly is proving that... Kelly did not prove that she had needed health insurance. Okay, this is the part I wanted to get to you. This is the part I've been so excited to show you. This is the part I've been so excited to tell y'all. Free justice. Kelly Piquet attached a statement on page 24 in which she alleges that she is poor in the true sense of the term and has no means to cover the costs, expenses, and fees of the legal proceedings without jeopardizing her own livelihood. The Federal Constitution of 1988 stipulates that the state will provide full and free legal assistance to those who prove insufficient resources, from which it follows that a simple declaration of indigence is not enough for its granting, especially when the elements of the case file demonstrate the contrary. Hang on, I gotta ban this person. If you already banned them, good job. Good job. It is up to the magistrate, in light of the specific case, to objectively assess whether the necessary requirements for granting the benefit are present. According to the case file, the claimant, Kelly, received a salary far exceeding twice the national minimum wage and is not represented by a union. In fact, the claim of financial hardship alleged by Kelly borders on bad faith litigation, as it is, at the very least, incompatible with a person who publicly declares themselves on the internet as a citizen of the world. Therefore, the mere declaration of Kelly's inability to pay is not sufficient for the granting of the benefits of free legal aid. Fucking audacity, man. The fucking audacity of this shit. Attorney's fees, compensation for losses and damages. Summaries 21-329, the Superior Labor Court stipulate that attorney's fees are only due in disputes related to employment relationships when assistance is provided by the labor union. Professional experience, approval of receiving a salary lower than twice the minimum wage, or a situation of financial hardship that prevents the filing of the lawsuit without jeopardizing one's own or family's livelihood. I reject the request because the necessary prerequisites are absent. I also reject the request for the defendant to pay compensation for losses and damages in an amount equivalent to 20% of the judgment value, because the choice of an attorney and the execution of the contract were carried out without the participation of the defendants, who should not be held responsible for the costs arising from the aforementioned choices made by Kelly. And basically, the TLDR here is the judge's key rulings and filings, partially found for Kelly, unregistered employment period. The judge agreed with Kelly. Evidence showed that she was performing the same duties before her formal contract. The companies were ordered to rectify this and pay proportional vacation. Overtime. The judge rejected the company's claim that Kelly was a trusted employee exempt from overtime. She was awarded payment for overtime exceeding the 8-hour daily, 44-hour weekly limit, plus a 50% additional fee. Unpaid salaries. The company failed to prove that they paid her full salary for January and February 2013. They were ordered to pay the difference. Termination fees. The companies failed to provide the proper termination document, so they were fined as well, even though Kelly admitted to receiving money at dismissal. Now, even though Kelly had those wins for partial wins, I guess, these were the claims that were thrown out and rejected. Transfer allowance. Denied. The judge ruled that working in New York was part of her original hiring, not a subsequent transfer. Accumulation of function and model work. Rejected. The judge found her testimony and that of her witness insufficient and unreliable to prove these claims. A photo she provided was also deemed inadequate evidence. Moral damages and damage to image. Rejected. No evidence was provided that the companies conducted themselves in a way that caused her moral distress or improperly used her image. Material damages, rent, rejected. The judge found no proof the companies agreed to pay for her New York apartment, especially since she sublet it after her dismissal. Meal and transportation vouchers, rejected. She provided no documentation proving she was entitled to these benefits. Health and life insurance, rejected. Ditto. Free justice, rejected hard. The judge called her claim in poverty bad faith, pointing to her personal website where she presented herself as a citizen of the world. She was ordered to pay court costs. Well, she won some legitimate labor claims because the company was sloppy with its paperwork. She got exposed as a Let me try that again. Well, she won some legitimate labor claims because the company was sloppy with paperwork. She got exposed as someone willing to use perjured witnesses and make fraudulent poverty claims. The classic throw everything at the wall and see what sticks litigation strategy. The fact that she no-showed on her own poverty claim when the judge called her bluff, which is in like the timeline. I don't exactly remember when that happened, but it's somewhere. Shows what a fucking fraud she is. She's a fucking Nepo baby anyway. What does she care? Exactly. Like, this is so fucking pathetic. And as I said, I'm going to make these documents available to the public once this stream is over. So, make of that what you will. Anyway, I gotta pee real quick, so I'll be right back. And, well, that's good. And after that, we'll do one last Nelson Jr. case, and then we will get to what I've been hinting at, the, Piquet company being very fucking litigious. So I'll be RB. Fuck, I didn't push the wrong. back. Sorry for the delay. It kind of turned into a bit of a snack break as well because I realized I was kind of fucking hungry. Anyway, let's get back to business. So the last case I wanted to go over before we got into the auto track information was just a criminal case that Nelson Jr. is a defendant in. Because, of course, he's fucking involved in this. And, it's environmental crimes. Like, let me make this very clear. That's what fucking happened. He's being accused of environmental crimes. Along with, like, 2 other people. And I'm going to show you a basic explanation of what the fuck happened. And now we got the music back. Good. All right. How do we begin this? I guess we start with the beginning. So, this is the first document I found related to this is an ongoing investigation, ongoing case, so there is no ruling based on it just yet. But it is absolutely worth trying to comprehend. And a lot of these are just like short pages. And I'm looking to rip aloud the irony. The true irony in that. Oh, I didn't hit translate. Fuck. Open translation? Okay. Let's do this. The Federal Public Prosecutor's Office attributes to Francisco Jose Sancho Rios II, Juan Pedro da Rocha Moraes, and Nelson Angelo Piquet, Nelson Jr., the commission for crime of causing damage to a conservation unit. However, it offers a non-prosecution agreement proposal considering the following conditions for each defendant. A payment of the administrative fine as compensated for environmental damages. B, provision of services to the community for a period of 6 months at a rate of 4 hours a week. C, prohibition from leaving the district of residence without authorization for a period exceeding 30 days. Under these circumstances, I observe the penalty prescribed for the infraction allows for the offering of the benefit. Although the procedure establishes the celebration of agreement between the interested party and the public prosecutor's office with judicial intervention only in the hearing to be scheduled for the eventual approval of the benefit, it should be noted that it is not yet possible to divide the acts, so it seems more efficient to schedule a hearing or issue a letter rogatory to the proposal of the invested party. So, basically, these are just requirements regarding the trial itself. But basically, these people, the 3 defendants, were offered a non-prosecution agreement. Basically, do community service, do all this, yada yada. In exchange, we will charge you with environmental crimes. Only one of the 3 defendants took the agreement. And it was not Nelson Jr. So, we're gonna get to that. Again, these are like a lot of smaller documents for a larger crime.
Every day, once a day, give yourself a present. Don't plan it, don't wait for it, just let it happen. A new shirt in the men's store, a cat nap in your office chair, or 2 cups of good, hot, black coffee. Like this. The present.
This is just regarding how the hearing's gonna engage due to coronavirus. Irrelevant.
Man, that is the spot.
Again, irrelevant. This is regarding a file. Now, this is where we get the only one person accepted the non-prosecution agreement. Given the offendants Joao Pedro da Rocha Moraes and Nelson Angelo Piquet have not been located recently, the clerk's office shall arrange for their notification at the new addresses provided. The schedule of the hearing, including in relation to the third defendant, is postponed until after the respective lawyers have been registered. Fuck, that's not it. There's gonna be a lot of trial and error here because I do not speak Portuguese at all. And there are like 12 fucking files pertaining to this. This is also, again, just, a lot of these are just judicial shit. Like, again, half of this is just going to be me, like, trying to figure out which ones are the ones that we actually need to give a shit about. Okay. This is the one I was looking for. Okay, here we go. The federal prosecutor's office offered a non-prosecution agreement to Francisco, Joao, and Nelson Jr. Only the first defendant already has a lawyer registered in the case file. The others could not be found, although one of them, Nelson Jr., was summoned by substituted service regarding the scheduling of the hearing. Under these circumstances, I find that the difficulties in locating the defendant, Nelson Jr., including suspicion of concealment that led to a summons at a specific time, demonstrate behavior contrary to the interests of reaching an agreement, so that his appearance at the hearing seems highly improbable, especially since to date he has neither appointed a lawyer nor provided an email address. I order to issue a summons for the defendant, Joao, to be notified of the address not yet served, so that within 10 days he appoints the lawyer directly in these proceedings under the penalty of the proposal being considered rejected. Under the notification of Francisco Joao Sancho Rios II, there's his opinion, and now you may be wondering exactly what this proposal by Nelson Piquet Jr. is. Well, let's see if the next document shows what it is. Fuck. I didn't mean to do that. Open translation. This is just a reminder that, okay, this is just a reminder, this is just a reminder of what happened the last time. So, page 8. Again, I downloaded these at like I downloaded these like yesterday, just so I could like get them all together in one place. So some of these are files that I haven't exactly read yet. This is another one regarding the non-prosecution agreement, and they still can't find Joe, or whatever his name is. Okay. This is where it gets interesting. Hearing held remotely via Microsoft Teams. The defendant, Nelson Jr., was absent, despite the information provided by attorney Dr. Bruno Pérez Castelo Blanco in the previous series, stated that he would have interest in the formulation of a non-prosecution agreement, or making a deal. On that occasion, it was also agreed that the lawyer would appear with the defendant regardless of summons. Next, the Honorable Judge issued the following ruling. In the view of the absence of the defendant, Nelson Jr., designated given the difficulties of its location, although it was for comment within 5 days, author notified the hearing without prejudice to electronic notification of the signing of this record. There being nothing further to discuss, the Honorable Judge declared this record closed, which may be accessed by interested parties directly in the case file. So basically, he's not even showing up to his own, like, hearings at this point. Ah, fuck. Okay, so this is actually what happened. This is why they were being charged for environmental crimes. The Federal Public Prosecutor's Office attributes to Francisco Jose Sancho Rios II, Juan Pedro da Rocha Moraz, and Nelson Jr., as described in the initial complaint, the crime of causing damage to a conservation unit. In summary, it argues that the defendants freely and consciously caused direct damage to the... I cannot pronounce that for the life of me. We're going to figure out how to pronounce that together.
Lençóis Maranhenses National Park B.
Lençóis Maranhenses National Park by entering the primitive zone of the conservation unit with motorized vehicles, with the assistance of a local guide known as... What does that mean? I want to know what that word means first before I say anything I'm gonna regret. Okay, it doesn't mean anything. Morenho. A guy named Morenho without authorization. A non-prosecution agreement proposal was offered to the defendants. It's just a surname. I checked, it's just a surname. So we're fine. We're fine. Francisco expressed interest in the proposal presented. Joao could not be located despite several attempts to serve him with a summons at the addresses provided, and Nelson, served by substituted service due to the difficulty in locating him, did not respond to the proposal, which resulted in the recognition of his tacit waiver. The hearing for the presentation of the non-prosecution agreement. Okay, so basically the first part is Francesco reached the prosecution agreement. He's fine. He's off the hook as long as he does what the prosecution agreement says. Now, here's where it gets interesting with this environmental crime. A new hearing was scheduled for the presentation of the agreement proposal to Nelson Jr. in view of the lawyer's information regarding the co-defendant's interest in entering into the agreement. Francesco submitted the criminal record certificate, so he's off the hook. He managed to do what was asked of him. And Nelson did not appear at the scheduled hearing. The Federal Public Prosecutor's Office requested the ratification of the non-prosecution agreement signed at the hearing with Francesco and the acceptance of the indictment in relation to defendants Joao and Nelson. He didn't even show up to his non-prosecution agreement hearing for going into a protected area with motorized vehicles. Take a moment and let that sink in. I'm gonna post that on Insta.com again as well. We're having fun here today, kids. Like, I know I was initially just kind of like a little off balance earlier because of just what happened right after my stream began, but now I feel fine. I feel good. And we're almost at like the big one. So what happened? We already went over what happened. We already went over what happened, Albert. I told you what happened. This is the report, having at the objective. So basically, they decide to charge Nelson Jr. and his friend. I'm not even going to try with that name again. There's no evidence to justify the inadmissibility of the accusation or evidence that the statute of limitations having expired. Only the investigation will allow for its proper factual evaluation. So, they are basically being charged with this shit. Albert, I'll tell you what happened later, okay? Okay. So, the investigation was distributed on March 27th, 2020. Hang on. Oh, wait, hang on. I gotta put the actual, like, timeline up again. Nelson. Okay. Here we go. So, case was distributed on March 2020. And the non-prosecution agreement was offered at around this time as well. Ergo why everyone's talking about COVID shit. Now, as we established, Francesco manned up, accepted the deal. And he got his agreement homologated at around 2024. Right around here. The new agreement was approved, basically. The other two could not be found. Nelson Piquet was served by certified delivery, but Again, even though his lawyer claimed he was interested in a deal, he no-showed to court on multiple occasions. The judge had to recognize this tacit renunciation of the deal. What's that? You don't believe that he didn't show to court multiple times? Well, these are the documents that show that he didn't show to court despite being summoned into it. God damn it. Come on. Difficulties in locating Nelson. The others cannot be found, although one of them was summoned by substituting service regarding the scheduling of the hearing. And, again, he was absent. The case is still active as of 2025. But I want to make something clear here. This fucker, Nelson Jr., will sue the government over a fucking perfume bottle, while simultaneously facing federal criminal charges for destroying a part of a protected national park. The absolute fucking... They're fucking parasites, you know? Just fucking leeches. He played the victim in civil court over a perfume industry buy, but he's actively avoiding responsibility for environmental destruction that could land him in... Well, he's not going to federal prison. He's rich. But, you know what I mean. It's just... Sometimes the audacity of a situation even, like... Okay. So I'm going to go through the actual, like, auto track ruling cases pretty quickly, so I'm going to take down the monitor for a second so I can just set it up. Everything else, Min will always have the audacity. Pretty much, Mia, pretty much. So give me one moment while I... Where's the display? Here it is. Take care of that. Okay, so it's this one. Next one is this file. Where are you? Where are you now? It's 10 and 10-10. Yes. Actually, no, wait. This is exactly what I wanted to do. There we go. Okay. So, as you should probably know, the Piquet family runs a company called AutoTrack. Very controversial company. They basically got a government contract under the Bolsonaro government without there being any actual competition for the role. And they've been involved in some very litigious shit in the past little while. And some of this is fucking pointless. So I wanted to go over a few of the lawsuits that I saw. So the first one started in 2019. I call it Debt Dodge Debacle, AutoTrack's pathetic attempt to squeeze blood from a stone. This is an execution of an extrajudicial title. Basically, AutoTrack tried to use a document, like a promissory note, to force payment of a debt without a full trial. The plaintiff, AutoTrack, which is the company the Piquets run. The defendant, Carl Alexander Newman, who owed the money. Now, initially, the case was distributed on March of 2019. But it got archived about a month later because no assets were found after searches in systems. Like, I think it's this one that has that bit. Oh, yep. After unsuccessful attempts to locate attachable assets, the proceedings remain suspended for 1 year pursuant to Article 921, Item 3 of the Code of Civil Procedure. During this period, the party failed to demonstrate any change in the defendant's assets. Therefore, based on Article 921, I order the case file to be archived without being removed from the distribution list. So basically, they archived it. They archived the case because they couldn't find anything that really warranted this case being necessary. Several attempts were made to expropriate assets to satisfy the debt in force without success. Therefore, due to lack of assets, the execution remains suspended. But it gets unarchived in 2022 for whatever reason. Why 2022? We do not know. But it gets archived again on the same fucking day. Then it gets reactivated 3 years later, in July. July of this year. So, the Piquet company basically unarchived this fucking lawsuit on multiple occasions, despite the court previously archiving it due to lack of real assets or evidence to speak of. They did fuck all to actually collect whatever debt was needed. Now, here's where it gets interesting. Back on October 15th, the judge announced the intercurrent prescription of the executive claim and extinguished the process because, after the suspension, after the first 1 year suspension, the period started automatically. And for extrajudicial titles like this, the period is about 5 years, as far as I understand, under Article 206 of the Civil Code. And since AutoTrack didn't act within this time, they basically got nothing. And the bottom line here is this case is a testament to the Piquet family's legendary incompetence. AutoTrack had a valid title, but was too slow, too disorganized, or too busy with other bullshit to actually collect. They let the statute of limitations expire for this, wasting court resources and their own fucking time. can't even win if the law's on their side. Oh no, not another ad. No! Well, while your ad is going on, I'm going to do the next set, which is number 9, right? That's number 9. Again, I am very inconsistent with my filings, so I don't quite remember how I filed some of these. I'm gonna like put these in a I'm gonna have these in like a better set, a better organization next time, I promise. Okay, and the files important with this one are okay, number 9 and the ones with 6 9s, 7 9s, 8 9s. So this one's important. Okay, the 3 9s is also important in the 4 9s as well. Not this one. And then the other one is 7 9s and 6 9s. So this is 6 9s. No, wait, no! I hit share on accident, but I didn't share with anyone, don't worry. And is 8 9 any important to us or no? Doesn't look like it. There we go. Okay, so this is the next case. I've titled this The Deck Collection Clown Show, Autotrack's Pathetic 4-Year Shit Show Against a Transport Company. Another execution of extrajudicial title, which again is just, you know, they're trying to use the law, the courts to force payment. That's basically what's going on here. This time it's a transport and logistics company that they are suing. Now, the case was initially allowed to proceed because the judge who initially found this found the filing basically certain and enforceable. So the lawsuit is admitted. The judge orders a series of acts to find assets, you know, So they're filing petitions, getting all of the evidence needed. But then we get to February 28th, 2022. No, wait, no, I misread that. Sorry. Basically, everything is filed. There are deadlines and stuff that everyone misses. And then comes... After nearly 2 years of fruitless searching, the judge basically drops the hammer. And this is basically what happened. Due to the absence of attachable assets, I suspend the case. No, wait, no, that's not it, is it? This is it. Sorry. So this is basically the suspension of the case. Because after about 2 years, nothing really happened, and they just... due to frustrated execution, basically. Because neither side really provided any evidence. But, after this, shit gets interesting. Because AutoTrack starts, like, filing petition after petition to try and, you know, get this case moving, but the court shuts them down. Especially during what is it? 9999999. During this case, the judge denies a request for time extension, telling them they can just file a simple petition, they find assets, and orders the case to be sent to the archives again. And then the judge denies new automated requests, searches in the systems, calling them useless and a waste of court resources since previous searches found nothing. And again, the litigants in this case didn't even, like, bother to provide evidence. Now, after this, you get a bit of false hope. On February of 2024, yes, the judge grants the attachment of the debtor's credits from payment processors. A couple months pass. Everything... ah, Lord. Just, like, there's so many fucking petitions after petitions after petitions. The case was archived anyway again in August. Like, there's nothing, there's no final sentence, there's no fucking victory to this. The core debt still remains uncollected. It's just so much back and forth that you just kind of have to take a moment and wonder, like, what the fuck is actually going on in these people's heads. And I'm probably going to do, like, a proper video on all of these lawsuits later on. I just want to, like, show them to y'all. To show that, yes, we have them. Shit's getting fucked. What was the next one I wanted to talk about? Oh, here's an interesting one. This is 1090. This is 7. So the files associated with that are 717374. We don't need to open 7.4, actually. No, we don't. Okay, so this involves some poor bastard named Manuel. Again, AutoTrack is the leeches. They are the plaintiffs in this. The defendant is Manuel Carlos Pera Lopez, who owed them money. Again, this is an execution of extrajudicial title case. AutoTrack claimed Manuel owed them money based on a contract with a form selection clause, but instead of collecting, they sparked a competence conflict that wasted fucking months. Basically, the courts argued, oh, is this supposed to be Manuel's home court of Piquets or Brasilia? So, it was first distributed April 2024. But the case was suspended initially in July, pending a competence conflict judgment. Basically what happened was AutoTrack sent this. They started the lawsuit in Manuel's home province, state of Imperatriz, and Imperatriz tried to suspend the lawsuit, like, hey, you're based in Brasilia, this should be in Brasilia. But then, in August, the STJ basically decides the conflict, declaring the Imperatriz court competent because relative competence can't be declared by a lower court itself. And we're gonna read a bit of the excerpt here. With all due respect, the court understands itself to be competent to hear the present case, or so that any decision might be rendered would be tainted with nullity. That learned judge based his decision on the fact that the parties not included in the enforceable contract a costs law stipulating the jurisdiction of this court. However, the division made ex officio arose after the defendant was summoned and determination was made to measures such as seizure of assets. Since this is a matter of relative jurisdiction, that lower court should have recognized outright the abusive nature of filing the lawsuit in that court, which did not happen. Furthermore, since the defendant did not allege compliance with the aforementioned choice of forum, jurisdiction to hear the case was extended to that course. In light of the foregoing, this court considers itself incompetent to process and judge the present case, which is why I raise a conflict of jurisdiction. I hereby give this decision the force of an official document to be forwarded to the Superior Court of Justice. But then, the case is ultimately suspended pending this competence conflict. Which is as stated here. On August 21st, 2024, the case is basically brought back to Imperatriz, meaning after months of... basically. In August, the Brasilia court receives the decision. They remit the case to Imperatriz. And AutoTrack basically had to start over in a new court. Which is why there is pretty much nothing else in this. Because the rest of the hearings happened in Imperatrice, and these are all related to Brazil. Yeah. A complete fucking waste of time, if you ask me. Trying to think of what else we can. What are the other cases? Because we did another shit show against. There's another shit show against this security company, and it's another like one of these cases where they file in the home court of the defendant, and that just gets fucked. So why don't I show AutoTrack getting sued over contract breaches? That's number 5 in my files. Mm-hmm. And the ones that I need are 5, 5, 1, 5, 2. Oh, those are the only 5 files, aren't they? Yep. Okay. So this is a little different. This is an ordinary civil procedure, which basically covers contract termination, material damages, indemnification. So basically, this company, CIEM, is suing AutoTrack for being shitty business partners. Which, valid. Absolutely fucking valid. So, the lawsuit starts. They gotta fix, a couple of things with the lawsuit. But, on September 18th, 2024, the court grants an early injunction against AutoTrack, ordering them to suspend all collections, remove them from the credit protection databases, collect their equipment within 5 days, or face daily fines for non-compliance. And we have that ruling right here. Finally, the requesting party has demonstrated the necessary requirements for granting the requested urgent relief. Indeed, in light of freedom to contract, no one is obliged to maintain a contractual relationship in which they have no interest, leaving the discussion regarding default and its consequences. Furthermore, the plaintiff, CIEM, presented extensive documentation consisting of communications that were allegedly exchanged with AutoTrack, which indicate, at least in summary proceedings, that there may have been a failure in the provision of the contracted services sufficient to recommend the suspension of any charges, at least until a final judgment is rendered. The urgency stems from the risk of irreparable harm if the regular procedural process is awaited, which could result in an increase in the amounts eventually charged to the plaintiff, as well as the unnecessary unavailability of equipment to be sold by AutoTrack. So, preliminary injunction is granted! Woo! I still don't quite know what that ping is. That caused me to lose my track of thought, sorry. So, AutoTrack tries to appeal the ruling, obviously. Here's all the appeals shit. But the appeal is denied. The injunction is maintained, as shown here. Conciliation hearing was initially held at a mediation center, but the case is continuing, at least through now, with various petitions and procedural moves. It's an ongoing battle. AutoTrack can't make it disappear. So this is one of like the lawsuits they're actively fucking involved in. And again, there's a lot more that can be said here, but I don't want to make up shit about the law when I don't know what I'm doing here. But it shows the Piquet family's legal terrorism model works both ways. When you constantly breach contracts and fuck over business partners, eventually someone's gonna fight back. And they're shitty business partners. They can't even honor their own fucking agreements, as we see here. Okay, the last four are ones that I want to talk about. At least in brief. Because, like, I can kind of feel my voice going out, but I want to, like, keep talking. I want to keep, like, showing y'all this absolute fucking horseshit. But I still want time to actually show all of these files on the internet, as well as you know what I mean. So we need none of these documents are needed. Okay. Well, this is an interesting one as well, because even though, like, AutoTrack is suing this woman named Mary for debts, they keep having to file for amendments throughout the months. But then their case gets fucking rejected on the 26th of March, 2025. The initial petition is dismissed. But then they appeal, and it's been bouncing back and forth ever since. They're still, like, pursuing this case despite not even filing the proper paperwork at first, the case getting thrown out, and now they're wasting even more money on appeals. For how much fucking money are they even trying to get? Like, what the actual fuck is this shit? Now, there are also a couple of cases where AutoTrack tries to fucking countersue in some kind of mutually assured destruction as well. So, I'm going to pull those up now. That would be file. Is it 3? No, it's this one. It's 2. 2. This is the next one. Nope, not share. Open with. So we need 21, 22, 23, 25, 26. All right. So, this shit show basically revolves around a contract for satellite tracking services for a fleet of trucks. Autoposto claims it properly terminated the contract and removed the devices back in June of 2024. But this is the filing where this is the filing relevance. AutoTrack then hit them with undue charges, quote unquote, like a sinistrality fee and a deactivation fee. Autoposto sued for no debt and damages, while AutoTrack Connor sued for unpaid fees and accused them of fraud with another company. Which is, as you see here, the plaintiff states in summary that it operates the cargo logistics sector and has contracted with the defendant for a satellite truck tracking service. It states that it attempted in various ways to contact the defendant through an authorized company, NordTrack, with the intention of informing them that starting on June 10, 2024, it would be uninstalling the equipment from its fleet of trucks. It states that in compliance with the contract, which established a 30-day notice period, on July 15, 2024, it made a payment for the monthly service relating to the month of June. It goes on to allege that despite the removal of the equipment, the defendant proceeded to charge for a semester fee, which was inadvertently paid. In conclusion, the plaintiff requests the defendant be ordered to reimburse and double the amount and duly pays the semester fee, as well as the declaration of the charges relating to the monthly fee on August 15, 2024, and the deactivation fee are enforceable. The defendant, AutoTrack, having been summoned, filed a counterclaim in which it asserts the invalidity of the communications sent by the plaintiff to the concessionaire. NordTrack, regarding the termination, said, since it should be the recipient of the request, it defends the legality of the charges made, which it claims to support by the contract signed with the plaintiff. And maintains the charges for monthly services continued until the equipment was fully deactivated. Regarding the deactivation fee, it states that the charge was due to a scheme between the plaintiff and another company within the same economic group through a transfer of accounts procedure with the sole purpose of avoiding payment for the deactivation as stipulated in the contract. Now, in August of 2025, as seen here, both sides partially win. Autoposto, basically won by not paying the huge deactivation fee, but AutoTrack also won by getting paid for the July and August fees and a smaller fee. So basically, it was just a legal clusterfuck. But even then, AutoTrack continued to file fucking appeals. Appeal after appeal after appeal. And basically the appeals ran out last month. But paperwork continues to linger to this day. And this isn't even like the first time they fucking countersue. Well, this isn't even the only instance of them countersuing. Again, I'm going to be doing a proper video. This is kind of just a preview of the lawsuits that we're involved in, and we haven't even gone to the actual meat of some of these. But I will be posting these on the internet within a few, and yeah, sorry. Usually I'm not streaming for this long, so I kind of am at a loss for words, really. Especially since we're talking about all this legal shit. But I wanted to show just how fucking parasitic the Piquet family is. Especially since we now have, like, official court documents showing, indeed, that this is the fucking case. And it's frustrating to see that people still support the family, support everything that they say and do, despite all the evidence pointing to the fact that they're terrible people who deserve nothing but terribleness. And sure, some of this stuff might not be as fucking damning as what might be hinted at, but I think this shows a lot of how they are as people. Especially with, like, Kelly's labor and nail salon lawsuits, Nelson Jr. facing environmental crime charges, him suing over a fucking perfume bottle. There's a lot to unpack, and I feel like it's absolutely worth trying to dig into, because holy shit, there is a lot. But there's not really much else I can say here, except, you know, thank you for sticking around for this long. And soon I'm gonna try and get, like, a proper video for all of this out in the near future. But, as I said, my first priority is getting all of this online. But, thank you all so much for watching. And, I'll see you next time.